Welcome to Sandoval Video Box. This is a live stream of the April 2022 Sandoval Board of Directors meeting from the Sandoval Clubhouse. Viewing of this meeting is available at your convenience 24/7 on the YouTube channel Sandoval Video Box and Sandoval's website www.livesandoval.com. If you haven't already, consider subscribing to support Sandoval Video Box on YouTube by clicking both the subscribe button and bell to be notified of future meetings and presentations. The meeting will begin shortly. If you, the viewers, have any comments or recommendations you would like to see in future live streams, email your comments to sandovalvideobox@gmail.com. Sandoval Video Box thanks you for your support by subscribing and your participation by watching this meeting.
Good evening, everyone. If we could stand for a Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, we'll take attendance. Marilyn Stout. Are you here? Stan Toro.
Here.
Is that me? Dave Ciganek.
Here.
Todd Rinehart.
Here.
Kathleen Falastini. Grady.
Here.
John.
Here.
Thank you. So quorum is met. Our first order is resident comments. Mr. Robertson, did you want to talk on litigation or did you want to talk now? Oh, so sorry. Later or now? Now. Okay. Okay, litigation will be after John gives his. Is that okay? Did you want another part now, though?
I'm going to make a comment that says I'd like to have our two separate sheets like we used to, so that we have our resident comment before and after, so that I'm clear on what I'm doing.
Okay. Well, I have one sheet, so does anybody want to ask any questions about the agenda items now other than litigation or the presentation by Dave and Todd, because we'll have question and answer after each of those. Okay. Scott?
Kathleen,
Yeah.
just before I get up, is the color of the cages an agenda item?
Mm-hmm.
Yes, it is. Yeah.
Good evening, Scott DeFilippis, 2612 Stony Hill Court. I do want to mention just one thing about the color of the cages. As a resident, I'm opposed of changing the standard white. More importantly, as a realtor whose brokerage has sold dozens of homes in Sandoval, I am personally against that as a realtor. I believe everyone in this community has looked at consistency when we bought our homes. So it's in the docs that it's supposed to be white. We have white gutters, we have white fascias, we have white soffits. And I believe as a realtor that we're doing a disservice to the residents and their property values in changing that color, because we'll have a white cage, a couple bronze cages, a white cage, a couple bronze cages. And I personally believe as a realtor that it will adversely affect the property values. That being said, Sandoval has just had a record sale that closed on Stony Hill Court for $950,000. So I think we're turning the corner in Sandoval with our property values inside the gate. And I would hate to see, us encumbered by that.
Thank you.
Thank you.
Thank you.
HOA dues, it's not.
Oh, it's not on the agenda, though. I'm so sorry. I can only address agenda items.
You have a finance piece of the agenda?
Are you saying anything about
Nothing
HOA?
about dues.
Nothing about dues. Can I hear the question? Do you mind?
Finance question.
Do you mind if I take the question? I'll take the question quick, please. Go ahead. Quick. Go ahead.
Yeah, it's been an ongoing.
Your name and street.
Sorry, Eric Wright. I'm on Hopefield Court.
Thank you.
It's been an ongoing concern of a number of people, but for me, that we have outstanding HOA dues collections. And I was just wanting to know what the status of those are and what the amount is.
Okay, Dave will, if not tonight, he will be addressing that. Thank you very much. Nothing yet?
Good question.
You want to wait, Mr. Robertson, till later? Okay. Okay. Okay, approval of the board meeting minutes from March 24th, executive session February 28th, and March 16th and March 29th.
Make a motion to accept. I'll second it.
Okay, everyone in favor, aye?
Aye. Aye.
Aye, we're good. Thank you. Well, that was fast. Now I'm up. Okay. Should have stalled a little longer. Sure there's no other questions? Okay. So I wanted to thank everyone for coming tonight. I believe if many, if not most of you, are here for discussion relating to the Taylor Morrison litigation settlement, in which Sandoval has gained ownership of the property formerly known as the Sales Center. Tonight we will discuss the good, the bad, and the ugly regarding the litigation process, which began in 2019. Jonathan Huffman, our attorney from Morgan & Morgan, is here tonight to inform us how this process began, what Sandoval was seeking in the claim, what worked, what didn't work, and how litigation ended with the settlement offer. The past board was informed during an executive session held on February 28th to the offer to settle by accepting the Sales Center property, along with a monetary offer to settle the counterclaim made by Pope Properties. A vote was held amongst the 6 members present, with a 5-to-1 vote in favor of settlement versus moving forward with litigation in court. The final details and paperwork for the settlement were completed on the day of our election, March 10th. The very next day, I, as the newly elected president, was instructed that my first duty was to sign the settlement agreement resulting from the vote, which took place just a few weeks prior. Tonight, after Mr. Huffman's presentation, we will have a question and answer session for the residents to ask questions of Mr. Huffman. Following that will be an important presentation of the work done by the present board regarding the expenses that Sandoval will incur to prepare the sales center for its ultimate disposition. The options considered have included selling the property, keeping it, and leasing it out to a local business, or keeping it and using it for Sandoval community uses. The presentation will provide important information for our community's future decisions about the property. We will, again, allow residents questions regarding that presentation as time allows. I'm going to allow time. The board will then hold a hands-on workshop with residents in May, tentatively May 21st, a Saturday, for the purpose of a collaborative effort in evaluating the options of selling, leasing, or keeping the property. Those results will be shared with the community via email, and then we will ask homeowners to vote upon the options in June. I'm aware that some residents have prepared questions, and for that interest, I'm grateful. I ask that if your question is answered, that you don't take additional time in repeating any questions. Please listen to the presenters closely without interruption, as your questions may be answered by them during their talk. And finally, I ask that you allow me the courtesy to direct the question and answer portions in a timely and mutually respectful manner. No shouting out, no disruptions. Let's enjoy a smooth meeting tonight filled with valuable information and answers to our questions. Thank you. That's all I have for this evening. Board Treasurer Dave Ciganek.
Thank you, Kathleen. Treasurer's report for the board meeting of April 28th, 2022. There's 5 areas of topics I will be reporting on. 1, taxes. 2, the Finance Committee. 3, month-end financials. 4, our 2021 year-end audit. And 5, the depository insured accounts. As far as taxes, number 1, our Florida Department of Revenue taxes are paid. As instructed by our CPA, we filed our 2020 federal tax return, Form 1120H, this month, and payment will be made of $5,125 before the due date of May 31st, 2022. 2, the Finance Committee. 5 residents have applied to volunteer their time and talent to the Finance Committee. I reached out to each one this week to answer any questions they may have in serving. Each one confirmed their interest and commitment to serve on the committee. I am confident we have a group of well-qualified members with financial backgrounds ready to get going. So many thanks to those residents that stepped up and volunteered. The month-end financials. The previous Finance Committee, which at the time included 3 board members, met on April 12th with Kathy Williams of Associate Management to discuss the month-end February 2022 financials. We thank her for her diligence and allocating her time to address our questions. Here is a sampling of some of the items addressed during that meeting. Consolidating the various bank accounts into fewer accounts. Checking the status of closing the Truist and CIT accounts. We wanted to know who is or are the signers on these accounts. We wanted to verify the 2021-2022 signature cards and get statements from each bank financial account. We talked about certifying names and contact information of all signers and the login access for each bank and financial account. We wanted to understand the accounting entries that are needed to clear up the due to from references that are in our financials. As far as researching the line item called Other Current Assets, which is on the asset side of our financials, we wanted to identify who they are, what they're referred to, and how long we've held them. We wanted to also provide accurate accounting of the clubhouse construction expenditures. We wanted to review, as we normally do, income and expense budget line items. And we talked about researching ways to provide insurance on the monies exceeding the FDIC limit while staying within our existing 6.10 bylaw statement. The consensus is that our financials will be a work in progress over several cycles as we work in close collaboration with our partner, Associate Management. Month-end 2022 financials were received this week, and our newly formed Finance Committee will make it their top priority to review them at its May 2022 meeting. We have the commitment from Kathy Williams to attend Finance Committee meetings as her schedule permits. Number 4, the 2021 audit, year-end audit. The audit is complete and will be reviewed at the Finance Committee meeting at its next meeting. As far as the depository insured accounts, we will also address that by the Finance Committee at its next meeting. That's the end of the Treasurer's report.
General Manager's report. Nothing to report. Okay. I'll include it in my GM. Okay. Just to save time. Okay. Tonight we're going to address standing committees for 2022-2023. The standing committees are architectural review, communications, covenant violations, finance, lakes, landscape. Amenities has been changed to recreation, safety and security, social. We added strategic planning, and in the works is neighborhood reps. Ad hoc committees are reserves, gate/and Vera, traffic, capital improvements. And coming to an end is design committee, maybe 1 to 2 more meetings. Litigation ended, CenturyLink ended. The board of directors will be revamping the committee charters. Upon review, we found conflicting information or wording that requires correction and updating, so that will be done soon. So I make the motion now that we vote on the standing and ad hoc committees. Anybody second?
I'll second that.
All in favor?
Aye.
Nobody against. Thank you. Covenants. Okay, that's me again. Okay. So for covenants and violations, our compliance administrator, Terrence Battle, has reported over 170 violations at this time, and friendly reminders were mailed to residents. Compliance for the reminders is currently underway, and violation letters identifying those issues are being processed at the present time, and after 2 weeks, Terrence will canvass those homes to verify if violations were in fact cured. For those remaining non-compliant, the Board of Directors will review for imposing of fines and notice of hearing by the Covenants Committee at the next board meeting. The Board of Directors have received the current violations and reviewed each. Many were gate arm and bar strikes and parking violations. So we have previously reviewed them, and now I make a motion to accept the violations, to charge $100 fine to each, along with any repair fees that were incurred with the gate strikes and the bar strikes, and forward recommendations to the committee for hearing on May 19th.
Second.
Second, thank you. All in favor?
Aye.
Thank you. Okay, ARC, you're up next, Grady.
Yes, the ARC committee received an application to change the pool cage color from white to bronze. We tabled that, but we got into conversation about it. The thought being that we require our homeowners, our residents, to use the invisible fence or the bronze aluminum fence. And it occurred to us when looking at a couple of the homes here in Sandoval that have the bronze pool cages, that they do, like the fence, kind of blend into the background. You don't really notice them like you do the white fences. So the entire team was unanimous in requesting that the board add the bronze pool cage to the color options. To Mr. DeFilippis's point, I appreciate his comment, but other realtors may have a different opinion. The choice to be able to do that, since we're already requiring someone to put in a bronze aluminum fence as an invisible fence, and that would have to attach to their white aluminum cage, which, granted, while their next door neighbor may have a white cage, there's no difference in the color differentiation between the bronze and the white when you've got a bronze fence and a white cage. So the ARC recommendation is to add bronze color to the pool cages. I would move that we add bronze as an option for the pool cages.
Second.
After the second.
Okay, any discussion before we
Yes.
take a vote?
Yes. I understand Scott's meaning and maintaining our values. I, too, am a realtor. I've been selling property in Cape Coral for 21 years. I've spent many, many hours and miles on our canals in my boat looking at houses. And I'll tell you, if you look at the bronze ones, they do disappear. White ones you can see. To me, the bronze is far more aesthetically pretty. I don't see how it's going to hurt our property values for those that still have white cages. Nothing seems to hurt our property values today, as you know. But I would certainly encourage our residents to exercise whatever option they think is best for them, and let them do it.
Anybody else?
Just a quick question. Is this a one-off request, or is this a consistent request?
No, it would be a consistent request. The issue is that we already have some homes that have the bronze cages. They didn't get approval through ARC, and we're not looking to grandfather them in. But for people who do want to refurbish their cage, you can have the screens replaced, have it sanded and painted. You can change your white cage to a bronze cage. But it's just that the option is there, and it makes sense to allow the same color as the fencing that would be in your backyard. The pool cage will be in the backyard, won't be visible from the street. On the lakeside, yes, it would be, but we're already doing the bronze fencing as your only option. So to me and to the art committee, it just makes sense that we do allow the bronze as an option as well.
And your proposal is to change, and I apologize if I get the terminology wrong, the standards or the guidelines to reflect this?
We're going to hear about this every meeting, aren't we?
No, I can't remember.
It's the standards. Yes, they will be not changing them. With the only exception to that is that they're just adding bronze as an optional color.
Did the committee do any reports on impacts to property values as Mr. Deepa?
No, we look at it as being similar to the last roof change that the board approved. If we're going to start allowing, many of the homes in the first couple of phases are beginning to age out and are ready to be refurbished. And so we're looking at people putting in new tile roofs with different colors. We're allowing them to use different paint colors. And this, to us, just seems like the natural next step to allow. The consistency is great, and from the front of the homes, this won't change that consistency. But it does allow people an option to match up to the fence that they may or may not have.
And the second thing to that is this doesn't affect front entrance screening at all, does it?
No, not at all. No.
Marilyn?
Yes, Grady, you indicated that there are already homes in Sandoval that have the bronze cage.
Yes. Yeah, some people apparently didn't realize that it was a no-no and just did it. I think that Sean may have approved one of them. There are not a lot of them, but
there are some.
Yeah. And the reason that they stand out now is because, it just wasn't allowed as an option.
Any further discussion, anyone?
One other quick thing.
Sure.
The art committee was unanimous in this?
Yes.
Call for the question.
No questions? Okay, do we want to take it to a vote?
Sure.
Okay. All right, all in favor?
Aye.
Aye.
Aye. Anybody against? No? Okay, set motion. Bronze fence allowed. Delinquencies? Dave?
I'll
Yeah.
make this motion. So we had a gentleman talk about dues, but I think he was talking about overdue dues, if I'm not mistaken. And that would come under kind of a caption of delinquencies. And we are being, I guess, we're recognizing this very, very highly, and our manager is really paying a lot of attention to it. It does come a point in time, though, where some of these delinquencies just get so far in advance that the next recourse is to refer them over through the legal process. So what I'm making a motion here tonight is to have an approval for our management team, Kathy, to forward delinquent accounts of 120 days or more to the attorney for collections.
Anybody second?
I'll second it.
Okay, any
I
discussion?
have a question.
Go ahead.
How is that different from today?
Well, the policy is a policy that is probably not revised,
Okay.
and it's not definite.
But what is it?
As to the 120 days, it's kind of out there.
So it's left up to whose discretion now?
Well, probably the management at this point. It could be our discretion. There was a policy that I read dating back to Pope. It was ambiguous as to how this would be addressed. So we don't want a case where there could be 2 years of delinquencies, and now we're looking at it, and it's still 150 days, and we're still not, doing that. So we really want to attend to that.
It's okay to ask Kathy what she thinks?
Certainly.
What's the question? I'm sorry.
Automatic roll going to the attorney with 180 days delinquency. Is that something?
That's actually very much a common practice.
Okay.
We are required to keep it for a bit. They used to be 90 days, and they upped it to 120. And then we still have to take
Everyone
that action.
can't hear that because.
Now, we still have to take that action. I can't give legal advice on it, but I can tell you just from past experience, used to the board would vote that they go to the attorney after 90 days, and then it got up to 120. So by the time it's 120 and they do all the due process, that allows them then to go to proceed to the collection process for it.
So,
But we send out letters before that from our end. They're still given ample notice that this is going to get turned over to collections. You do have pages and pages, I have to tell you, of people that are very far behind. The highest, when I ran the report, the highest one was a little over $16,000, and the lowest one was $1,600. So you do have several that are ready to move on.
sooner the better.
Oh, yeah. Yeah, absolutely.
And
Do you need me to say it all over again, or just a portion of that? I said your range right now, when I printed it the other day, the highest one was a little over 16,000 in arrears. And then the lowest one of the ones that are 120 days or more was a little over 1,600. So we do have several that we can start prepping very soon.
And since you mentioned that $16,000 amount, I do want to clarify that one has already been filed.
Yes, that
The
one's
lien's
already
already-
with the attorney, and we actually have 2 properties right now that are with the attorney that we've had liens filed. And when notice of lien on one of those was received, she was in the office within 48 hours and paid her account up. So that
thank you.
So it
gets
works.
people-
It works.
gets people working.
Any further questions? Marilyn?
Dave, was there a dollar amount connected with the 120 days?
I don't think it's so much a dollar amount as it is the aging of the delinquency.
I don't think I have a problem with
I
that.
think the 16,000 is for
Automatically
2
sending it up. I don't think I have a problem
years,
with that.
Oh, me neither.
correct? So we could have a situation where it's not as much within 1 year. So it's really the 120 days, which is what is defined by. Yeah, it's defined by kind of a legal process, and we want to make sure that we're right on top of that. Yeah, exactly.
Okay. Any further discussion on it? Okay, so let's have a vote. All in favor?
Aye.
Aye. Nobody against? Okay, thank you. Okay, moving on. It is time to introduce Mr. Jonathan Huffman from Morgan & Morgan. Thank you very much for taking your time to come here and speak with us tonight. It's greatly appreciated. Very much so.
Absolutely. Can you all hear me okay? All right, good deal. So like she said, I'm Jonathan Huffman. I'm one of your attorneys. I was your lead attorney, as it turned out, for the Taylor Morrison litigation. I'm with Morgan & Morgan, and it was our privilege to represent Sandoval, and not only am I your attorney, I'm actually a resident too. And I was happy to hear I'm not on the delinquency or gate list or violation agenda for tonight, so I guess we'll save that for later. So this is a dispute that had been brewing for a while. It actually began brewing while Taylor Morrison was still in control of the community. Way back, 2013 was really a key year for this dispute, and some of the conduct of Taylor Morrison was fairly reprehensible, as some of you know. I know some of you have been involved with this claim in different capacities. The biggest issue was, well, I guess before I get to the financial issues, the case was presented to us at Morgan & Morgan as a construction litigation case. We were asked to look at issues like premature erosion of asphalts around some of the cul-de-sacs. What was another big one? Drainage issues in Blackburn. Remember when we had those sort of historic storms, Harvey and Irma? There was significant flooding really throughout Cape Coral, but pronounced in certain areas of the community, and Blackburn was one of them. And so after doing its own investigation and working with the Becker and Polyakov firm for some time, the neighborhood came to us and presented those claims as a construction claim.
And we hired an engineering firm that we've worked with before. Morgan actually has a pretty good track history or track record against Taylor Morrison. We sued them up in a community near Orlando and popped them for, I think, $7, $8, or $9 million. And that was pretty fresh in their mind. And actually my partner who was going to pursue those construction claims for you all was the same attorney who got him up there, Paul Sangiovanni. So we made sure he was on the case, even though he's from the Orlando office for that reason. But we brought an engineering firm that we're well acquainted with. They do excellent work down here, and they spent some time in the community and looked around. And their conclusion was basically, guys, this is a nice neighborhood. For being 15 years old at that time, I think, baking out in the South Florida sun, you're going to see some of the asphalt issues due to irrigation systems on the islands, and what was the other issue again? The Blackburn. They looked at that and they said, that's a 100-year storm that we're talking about. You're going to have some backup, and in fact, we interviewed some of the residents on Blackburn who were in the areas that were designated to us as most affected. And those folks denied that it was an ongoing problem. Yeah, there was a bad water event because of those storms, but they denied that it was an ongoing issue. And so, at the end of the day, we took a good look at those construction claims and ultimately determined that was not a case that we were going to pursue. And so we went back to the board with that, and the board understood and certainly had the option to go a different direction if they wanted to, but ultimately decided that they wanted us to still look at some financial claims concerning Taylor Morrison. And that's what really began in 2013 that I was getting to before. And those financial claims were things like this. And like I said, some of the conduct was fairly brazen. Taylor Morrison, for a time, I think it was 14 or 15 months, may have been a little longer, Taylor Morrison, for a time, was outright pocketing the association's reserve contributions. When we've all bought into the community, for me it was in 2019, you see on your HUD statement that line item that you owe the community. I think for me it was $1,500, maybe $2,000, something like that. Maybe it varies by section of the community, but we all make these reserve contributions, and for a time in 2013 and 2014, Taylor Morrison was calling those a participation fee. It was right in their literature, and they were just putting that money right in their pocket. Now, what they did to compensate for that is they jacked up the percentage of homeowner assessments that were allocated to reserves. It was something like $2 or $3 per door per quarter, something like that, and they jacked it up to like $32. And the effect of that was it moved a big chunk of money, $300,000 or $400,000, from operating into reserves to cover up for, actually more than cover up for, the money that Taylor Morrison was keeping. And like I said, we've got written evidence of this. It was fairly brazen. To their credit, some of your residents who were involved at the time caught them and called them on it. And they eventually paid it back. And there was John Stromer's company, Stromer & Company was the accounting firm, and apparently engaged some third party as well to look over the records and determine that money was eventually paid back. And we had our own accounting experts, and we subpoenaed the documents, as you might imagine, from Taylor Morrison, from the original developer, from Pope Properties, and we presented, we looked through all those things, and we have no reason to believe it wasn't paid back, but still very bad conduct. Along the same lines, and at the same time, and in part created by that situation. So Taylor Morrison became the successor developer, I think, at the end of 2011, maybe December 2011. In 2012, I think, was their first full year. Going into 2013, Sandoval had accumulated a surplus from previous years. And a developer like Taylor Morrison, while it's in control of the community, has two options for funding the community. The first option is they can pay assessments on their lots like any other owner. None of them want to do that. They want to be chintzy and save a lot of money. So the second option is they can agree to fund any deficit, any operating deficit that accrues. And so the way that they did this, at least on paper, by moving $300,000 or $400,000 from operating over to reserves to mask the fact that they were pocketing the reserve assessments, that helped to create an operating deficit for that year because that money was missing from the operating fund. And there were additional expenses that year that caused a deficit to be run up of, I think it was $671,000. And Taylor Morrison decided, well, we don't really want to write that check to Sandoval, so what we'll do is we'll go ahead and use its surplus that had been accumulated in previous years to plug that deficit. And that's what they proceeded to do to the tune of $561,000. And to his credit, their own accounting firm, Stromer and Company, to his credit, John Stromer picked up on that. And it's actually strange when you consider he's working for Taylor Morrison, the way that this is written up in the year-end audit report. The way he put it was there was an operating deficit of $671,000. Taylor Morrison has paid nothing toward that and instead has used surplus funds. $400,000 of that surplus was in the form of a CD. It was, certificate of deposit that the neighborhood held, and then there were other surplus funds that were used. $561,000. Here's the issue with that. There were two competing provisions in the Sandoval Declaration. The first one is a general provision, and it says that the Sandoval Board can fund operating expenses using a surplus from previous years as long as it's budgeted and as long as that budget is transmitted to the residents before the fiscal year. Nobody knew if it was transferred to the residents before the fiscal year. We've got the burden of proof on that, so nobody knowing is a bit of a problem. But setting that aside, the other provision says, and it's more specific, and in the law, the more specific provision often controls. So I thought we had a pretty good argument here. The other provision says that you look at each fiscal year in isolation. And during each fiscal year, if the developer elects to fund any deficit rather than paying assessments on its lots, during each fiscal year, you look at revenue in versus operating expenses out, and they simply pay the difference. So there's no opportunity under that second provision to use a prior year's surplus. But they pointed to the earlier one and said, well, there it says that the HOA can do that generally, that it's perfectly fine. So we had a pure legal argument on that, two conflicting provisions. Difficult to tell who would win. I thought we had at least a 60% chance of winning that if it went in front of a judge. But you could always find a judge that says, hey, it says they can do it, they can do it. And they had budgeted a prior year's surplus for use by the HOA. Now, the amount they budgeted was very small because I think this plan came together later. I think they only budgeted like $8,000 or $12,000. So they're talking about using an amount 72 times higher than that or something. But they had a colorable argument. Other claims included, it's some of our folks here from Associate know this well. When a developer is deficit funding a community, obviously they want to keep the deficit as small as possible. And one of the ways that they do that is simply by not fixing stuff that needs to be fixed. They simply pass it along to the residents to deal with after their term is over. Once they reach a certain threshold in terms of sold lots, they're required to turn over the community, turn over funds of the community. And so that there's a motivation there on the part of a developer, not just Taylor Morrison, but always, to kind of run out the clock and let stuff get unfixed. And there were issues, some of you know about. There was apparently a big crack in the lagoon. It was well known. Anybody could see it. It was leaking water. Some of the folks who planted trees in the neighborhood didn't, I guess, think they would ever grow up or figured they'd be long gone by the time they did. And so we've got roots pushing up sidewalks that have to be planed off. We've got roots pushing up driveways, although that's not an HOA issue. we had a section of sidewalk that was outright missing and needed to be installed. Some street lighting issues, some things that they really should have done on the association's tab, and then paid the difference in terms of those things creating a deficit that year. And we actually had some very, very good proof of some bad conduct in that regard. Pope Properties, the property manager at the time, for years, to their credit, Pope Properties was turning in budgets to Taylor Morrison, saying, calling for deficit spending, saying we need to do some of these things. And we, thanks to some of these residents who were involved at the time, we managed to get a hold of an email string between Pope Properties and Taylor Morrison's people. And Taylor Morrison said, no, go back and revise that. It needs to net at zero in terms of dollars in and dollars out. In other words, we don't want to have to write a check. There's not going to be a deficit or you're out of here. And so that was some pretty bad conduct in that regard. There were a few other miscellaneous issues with finances. There was a matter of $38,000 that was due from the original developer that kind of got carried year after year. Taylor Morrison paid it, but at the same time showed it as a credit to offset their deficit funding for that year. So did they really pay it? Maybe from an accounting standpoint, but if you pay it and then reach in and take it out for another purpose, is that really paying it? And then the other set of items was things like the fact that, particularly with the situation with the roundabout, where we weren't able to have visitors there because the city was, I guess, getting upset that it was backing up traffic in that roundabout, and so you had to use the north and south entrances for contractors and visitors. That north entrance, this is before my time, but the way I hear the story, it only had one lane coming in, so it was a backup nightmare as well. So it really needed a second lane, which was eventually put in. The developer didn't see fit to put parking at the dog park, so unless you kind of live within walking distance, it's not of a whole lot of use to you. So the HOA put in parking at that dog park. There were a few other things along those lines. And so anyway, we wrote up a complaint. I'm proud of the complaint. It was very detailed. Had a number of counts to it, and we sued the whole lot of them. We sued Taylor Morrison of Florida, Inc., which is the developer company. We sued every single Taylor Morrison director, maybe with one exception, because they had like 6 months of involvement at some irrelevant time. But other than that one exception, I think, we sued every single Taylor Morrison director personally. Every director that sat here for Taylor Morrison, we sued them. And we sued the two Pope Properties entities. And we were going to sue Stromer & Company, the accounting firm that went along with some of this as well, although they really did kind of call out Taylor Morrison on some of this stuff. And they cut a deal for a tolling agreement. It's kind of beyond what I'm talking about here. But anyway, the property manager companies, all the Taylor Morrison directors and Taylor Morrison itself, all sued. The counts were things like breach of the declaration, number of tort counts, if you know what tort law is, breach of fiduciary duties, aiding and abetting breach of fiduciary duties, constructive fraud, which is something people don't like to get sued for. And then I believe it was the last count, the parcel right outside the gate, the sales parcel property, that was the subject of a declaratory judgment count at the end. And basically, we alleged that it was improper for Taylor Morrison to take that property out of Sandoval. And here's what happened with that. The original developer, which was Cape Coral Development Associates, they may have called themselves something else, but they were the original developer. They put that property into Sandoval and, of course, erected the structure that's out there now and used it as the sales office. But when Taylor Morrison bought Phase 3 and became the successor developer, they said, that's a nice piece of property. We could sell that at some point. I think we'll go ahead and remove that from Sandoval. We'll take it, and we'll sell it at some point when we feel like it. The market's going up, so we'll sell it at some point. The problem is the declaration, the Sandoval Declaration says they can put whatever they want in terms of property into Sandoval. So they could have bought some of the vacant land and put it in. That's fine. They can take out property that had been designated for development and they simply change their mind. Unless that property has a structure erected on it. If that property has improvements, it can't be taken out of Sandoval. So we had a declaratory judgment count basically asking the court to declare that what they did was improper and that property should still be in Sandoval. Now, when I say, well, I'll tell you their defense to it, and then I'll get to that point. Their defense to that count was, yeah, but the declaration also says that while we're in control, we can do whatever the hell we want. And the problem with that is there's a Florida statute that says you can't have unreasonable provisions like that basically give a developer free rein to do whatever. So we had a pretty fairly complex legal argument on that point. When I say that the property was in Sandoval, it's not exactly common area. It's also not a lot. Like it's not, common area like this playground sitting on here. It's also not a lot on which, you'd build a house. It's sort of its own classification. It's strange. We really didn't have an argument that the property was owned by the Sandoval Association. At best, I think we had an argument that it should have been within Sandoval, meaning within the declaration, and within the board's ability to control, to some extent, its destiny. There's concern that if that property is taken completely out of Sandoval and sold, who knows what it could become? A 7-Eleven, Asian massage parlor, tattoo parlor, biker bar, although some people might like that. Folks in Vermont might not like it. So anyway, there was concern that thing could become an eyesore and affect property value substantially. And even at best, even if we won that count, the most I think we could have claimed was that it was within Sandoval's control in terms of architectural review to some extent. They'd still have an argument about that. Under no circumstance would you really own the property, though, like you do now. So those are the counts in the complaint. In terms of the defenses, I don't know how many lawyers we have here. I suspect we have a few. One of their defenses that they really liked was statute of limitations. So for every legal action, there's only a certain amount of time you can bring a legal cause of action on. It expires at some point. Sort of the default rule in Florida is 4 years for things like fraud, construction defects, really a whole host of things. 5 years you get for written contracts, and there's a couple longer ones for judgments. Some are as short as 1 or 2 years. It just depends on the cause of action. And the theory that we've operated under in these HOA post-turnover cases is that the statute of limitations should not run until you have a turnover of the community from the developer to the residents. That theory hasn't been really tested. There's some case law, but everybody's afraid to test it because once you get a bad result one way or the other, it sets a precedent. And here we did sue on time in terms of when the turnover occurred. But one of Taylor Morrison's, and I believe Pope Properties' arguments was that, yes, that's true, but the conduct occurred much earlier. So the conduct of taking that parcel out of Sandoval occurred end of 2011, maybe January 2012. The conduct of misappropriating the surplus to plug that deficit occurred in 2013. The conduct of pocketing the reserve assessments took place in 2013 and 2014. We weren't even consulted by the time those periods had extinguished. And Taylor Morrison's argument was, even though there's this concept that the clock doesn't start to run until the community's been turned over. In a situation like this, where you have sophisticated residents who are raising hell about what was going on, and who actually engaged counsel, who had representation on the board, and who were making legal demands upon Taylor Morrison through counsel, when you have a situation like that, the clock really should start to run at the time they knew of the conduct and the potential damages. And so they were arguing that the whole case, well, that most of those claims were time barred. And I can't say that I can't call that a frivolous argument. They could have prevailed on that. They raised a number of other defenses as well. They picked up on the fact that while some of the conduct is clearly bad, it doesn't necessarily translate into damages. So, for example, if they pocket $150,000 or $200,000 or whatever it was in reserve assessments, but proceed after they're called on it by some of your good residents who were paying attention, proceed to give it back, and it's noted as such in the year-end audit for that year, are you really damaged? Certainly it's bad conduct, and we beat it over their heads during the case. But not all that I've listed necessarily translates into damages. And that was the message communicated to me very clearly when we met with our accounting experts. And we picked good ones. And how do I know we picked good ones? Because Taylor Morrison tried to hire the same guys. And they said, you know, we hope Morgan & Morgan appreciates us because we just turned down Taylor Morrison. And they tried to hire us for the same case. And these guys know what they're doing. And when they looked at all the documents we fed to them and the nature of these claims, they were not real high on the case, to be honest. Their message communicated to me was a lot of this stuff, because they were called on it, they fixed it. Yeah, the conduct was bad, but you aren't damaged if they put the money back. And their answer to a lot of the stuff, like needing an additional traffic lane up north, and there being no parking at the dog park, some of the stuff that's missing, the sidewalks lifting and needing to be planed off and fixed, the pool crack. Our own accounting experts' answer to a lot of that stuff was, guys, Taylor Morrison turned over $2 million in reserves, and it's not even clear that they were required to establish a reserve account, but they did. They commissioned multiple reserve studies, and they turned over $2 million to the association. That fixes a lot of pool cracks. That puts in a parking lot. That fixes sidewalks that are having tree root issues. So the accounting experts didn't like that. They didn't like my argument on the conflicting provisions with the surplus. They thought we were likely to lose that. I disagree with them, and I'll take my own advice on legal matters over an accountant. But yeah, I mean, they kind of tried to talk us out of the case, but we persisted, and we subpoenaed thousands of documents from Taylor Morrison, Pope, the Pope Properties entities. Dealt with Stromer's attorney, and it was interesting. At the beginning of the case, folks were gung ho. You know, we're talking with Keith Pope through counsel, and he's saying, "I know where all the bodies are buried. I'll help you fix Taylor Morrison." And John Stromer's kind of saying the same thing. But once we got into the case, they all sort of clammed up. We met with and interviewed witnesses who were involved with things at the time, and the witnesses basically supported the idea that the money got put back. The other thing was Taylor Morrison tried to raid reserve fund for operating expenses. It was actually in connection with that same year. They, to the tune of like $125,000, they just called operating expense reserves and tried to reach into that cookie jar and pull out $125,000. And again, thanks to your good residents who were involved at that time, they relented something like 85% of that. There's always some question about whether stuff is operating or reserves, but they agreed to put that back. So anyway, the witnesses that we interviewed for Sandoval, including residents who were involved back then, yeah, the conduct was bad, but they couldn't support the idea of there being damages from things like the reserve contributions because it was paid back. And so that's, that's kind of how that went. And the people that would talk to us said, we watched Taylor Morrison like a hawk. They didn't do anything else. We don't think there were damages there. And other folks just plain wouldn't talk to us. People move away, and the last thing they want to see is a lawyer calling them. So what you'd have to do is open a local action there and drag them into court, and then how good is their testimony going to be for you anyway? So the case went along, and we mediated fairly early. And I can't talk about what happened at the mediation because that's prohibited by statute. But after the mediation, the parties continued to negotiate, and Taylor Morrison's position was firm that they simply weren't going to put any money on this. But the discussion changed to the piece of property, which was the subject to, I guess, count 10 of the complaint. They had been listing that for sale for a while, and they couldn't do anything with it because even though we didn't have a lis pendens on it, and you don't want to lis pendens the property because then they can sue you for slander of title and things like that. But just the fact that we had a lawsuit alleging that property was supposed to be in Sandoval essentially renders it unmarketable. And they weren't real happy about that. I didn't particularly care. But it became the topic of discussion because it's something we care about. We don't want a 7-Eleven and so on out there. And it's something that's worth money. How much it's worth is subject to debate. But it's a valuable piece of property. There had been offers on it north of $600,000. Until recently, no one had suggested that it was worth less than $600,000. Taylor Morrison produced a professional appraisal that was a little dated, like a year, valuing it at $600,000. Before mediation, we got a broker price opinion at $625,000. After mediation, as we're getting into settlement, we got another broker price opinion from someone who's very familiar with the community and does commercial real estate at $750,000, I believe. And Taylor Morrison had it listed for $800,000 and had turned down offers north of $600,000. So that was thought to be a nice way potentially to settle the case. And as we're looking at the feedback from our experts, the feedback from the witnesses, and the thousands of documents that have been produced, which we went through, and one of my associates compiled like a set of the greatest hits from that stuff. And I looked through that, and there's just not much there. Because it's a case where liability is great, but damages aren't. And there are cases like that. And it became clear to me what's going on, that we've got some scary allegations from Taylor Morrison's perspective. But the farther we get into this case, if we start deposing the people I've talked with or listing them and having Taylor Morrison depose them, and they start finding out that these claims, these stinky conduct claims that don't turn into damages, they start finding that out, and they have their own expert spend all kinds of time looking at what our experts had and then some. There are cases where the farther you get into it and the more stones you overturn, the more the claims are worth. And we like those cases. This was the opposite of that. The farther we would have gotten into this case, and the more that Taylor Morrison came to know what I know, settlement value would have gone down. And they were still talking about no money, but they were interested in doing a deal on the property. And as your attorney, I have to envision some different scenarios. So we know how this turned out, and I'll spell it out for you if you're not familiar with the terms of the settlement. But, well, maybe I should do that first. So presented with all that information, after months of negotiations, Taylor Morrison's in kind of a bad spot procedurally. We have an opportunity to settle the case for them giving Sandoval a deed outright of the sales parcel property, the 1.6 or 1.7 acres out there. So you get the deed to the property outright. You get some cash. The cash portion ended up being smaller because in the midst of all this, Poe Properties sued Sandoval separately up in Sarasota for indemnity, saying, we got dragged into this unfairly, this is between you and Taylor Morrison. A defense case is not one Morgan & Morgan can handle on a contingent fee, so that's a case where Sandoval would have to engage counsel and pay fees at $300, $400, $500 an hour, whatever it costs. So we had to settle that case brought by Pope. We had to settle those indemnity-related claims. And so the cash component was $25,000. The ask was higher, but the cash component ended up being $25,000. The cases brought against Sandoval up north were to be dismissed with prejudice, meaning they can't be filed again. So that's all over. Pope has no claims against the community, which is something we're concerned about. So we took care of that. And that's pretty much. I left out the nicest thing. So I said it began as a construction case. During the case, it was discovered that there may be very well some construction claims involving the Phase 3 lakes. Those are the lakes that were constructed by Taylor Morrison. So the previous phases 1 and 2 were built by the original developer long ago. Taylor Morrison did the Phase 3 lakes far more recently, 2019-20 kind of time frame, from what I'm told. And the board investigated that matter, had some folks look into it, and determined that there could be some design and or construction issues with Phase 3. I don't know to what extent it impacts homeowners, but I suppose necessarily if your property goes all the way up to the bank and maybe even reaches into the water, perhaps. Taylor Morrison's position was, we're not settling unless it's a complete settlement. We don't want to hear from Sandoval ever again. We don't want to be sued by Morgan & Morgan again or anybody else about Sandoval. So if we're going to settle, Sandoval's done. And there's not going to be anything that comes back and bites us afterward. So that was a difficult and heated topic of negotiation. Ultimately, we got them to relent. And there was a carve-out in the settlement agreement preserving that construction claim. So to the extent that some folks think that there was a 7-figure construction claim involved in all this, maybe there is. That claim is preserved. And I'll tell you, as a litigator, to have a carve-out like that in a settlement agreement is unheard of. It does not happen. If someone's going to buy their piece, they're going to buy their piece. They don't want you getting a second bite later. But we made it happen. And so presented with all that, the board took a vote, as was mentioned, and voted 5-1, 6-1?
5-1.
Okay.
6 members.
Voted almost unanimously to authorize us to make a deal for deeding the property, the lawsuit against Sandoval going away, cash from Pope. I was instructed to ask for 75, but 25 was the threshold that would be accepted. And that critical carve-out for the construction issue. And so the board took that vote. I have my marching orders. We made that deal. And that's the deal that we have. Now, what I was going to say before, as your attorney, it's part of my fiduciary duty is to envision other scenarios and protect the community, protect my client. Also, as a resident, I have some concern, but protect my client from bad situations. And so let me paint a couple of different scenarios for you, because I know not everyone is happy with that settlement. That's the nature of settlement. Not everyone thinks it's a great thing. I understand the property has some issues. I know that's going to be talked about extensively. Just as the property had some issues, the claims had some issues, to be fair. So you have to bear that in mind. But let me paint a couple of different scenarios for you. If Sandoval had stayed with hourly counsel, and I've got nothing against hourly counsel, that's what I've been most of my career up until 5 years ago when I joined Morgan & Morgan. At the time we were consulted for the case, Sandoval had run up upwards of $100,000, $85,000, $90,000 in costs looking at these claims and hiring consultants to look at drainage issues and whatnot. if you had hired hourly counsel or stuck with hourly counsel, no matter how good they are, and you have good counsel, you would have paid $200,000 or $300,000 in legal fees. You would have paid 6 figures easily in expert fees. And that really doesn't leave a whole lot of room in terms of a recovery. There's no assurance it would go well after paying that money. So that's one scenario. Another scenario with us is, let's say we didn't make that deal and we proceeded toward trial. Well, there's going to be a motion hearing at some point, a summary judgment hearing is what it's called, on that claim for the misused surplus regarding the 2 competing provisions. If we lose that hearing and the court and the judge says, look, it says they can use a surplus, they budgeted some kind of surplus, the amount's different, but I don't have a problem with it. If the court says we lose that misused surplus claim, that's the bulk of the case. Really, the rest of it isn't worth pursuing. And so then you're left at their mercy to make a deal to avoid paying a bunch of folks their attorney's fees, their costs, their expert fees, if they win, on top of you paying yours. So that's one scenario. You lose that biggest claim and it guts the case. And then you're in a bad spot. Another scenario is we get past that hearing and we go to trial and we prove up damages. And by this time, Taylor Morrison is fully aware of which claims translate to damages and which claims don't. And so we have a trial on the claims that have real damages. And the biggest one, again, is that misused surplus. One of Taylor Morrison's arguments was what we did was move $300,000 or $400,000 from operating to reserves. It's basically moving one association account to another. The money stayed within Sandoval, and eventually it got turned over. So are you really damaged? So all of a sudden that $600,000 and some thousand claim, maybe it's only $300,000. So you get a judgment for $300,000. You pay us our fee, and then you pay your expert fees, and you get nothing. And that's a real possibility because the way that contingent fee agreements work is the lawyer gets paid their portion out of the recovery, and then your portion, any cost that we have advanced gets paid out of that, and then you get what's left. Accounting experts can run wild with costs. I've seen them be higher than attorney's fees. I've seen them put all kinds of people on the file, and they'll bill $1,000 an hour just for talking to each other within their firm. I've seen cases where they get to $200,000 or $300,000 in accounting fees, and it makes the case impossible to settle. Impossible to settle in a way that you get money. So those are the other scenarios that were in my mind. And when you consider that your main claim is worth $600-something thousand, and there's a good chance it gets cut in half, either because the money stayed within the association's accounts, or you just have to price in the risk of them winning on something like statute of limitations. All of a sudden, that claim's worth half that amount, and so you've got a $300,000 case. No one ever suggested that this property, until recently, I guess, no one ever suggested that this property was worth a penny less than $600,000. And so it becomes reasonable to make the deal that we did and avoid Sandoval having to pay fees to defend some case, some indemnity case brought by Pope up north. And so that's what we did. Was it perfect? No. Could it have been a lot worse? Yes. Would it have felt good to take them all the way to trial and pop them, maybe for $1 million? Yes. But I think what the board chose to do and instructed us to do was reasonable, and I stand behind it, and I'm ready to accept any criticism, insults, or anything else.
Thank you. Thank you.
Thank you.
Okay, the first person, Mr. Dave Hiller, if you would come up to the podium and. How many questions do you have? Okay. How long do you think you need?
Well, I'll tell you what, at 3 minutes, if you'll tell me, I'll cut it real short.
Okay, it's just between he and I right now. That's okay, but we'll fix the mic. I just want you to have...
No brothers.
Mr. Hiller, I want you to be able to ask the majority of your questions.
Okay. Well, obviously, I can't in 3 or 4 minutes cover the entire spectrum of what Jonathan said. Because I worked with him in drafting the case, I'm very familiar with what he said, and we could argue about this or that in terms of whether I would agree with it, but I'm just going to focus on one area. I think that President Falastini said that the case was filed in 1919. Actually, it was filed December 4th of 2020, if you recall. Is that fair? So by February of this year, 2022, it had been pending for 14 months, correct?
Sounds right.
Okay. Now, during that 14-month period, were any of the defendants deposed under oath?
They were not.
Was John, what's the auditor's name?
Stromer.
Yeah, was John Stromer deposed?
He was not.
Was anybody deposed?
No.
On February the 11th, you asked Judge Kyle to extend the discovery deadline by 6 months and move the trial date from May to December, did you not?
I don't recall the specifics of that. There was a joint motion filed by all 3 parties to move the trial date and related deadlines.
And the discovery deadline by 6 months, correct?
Again, I don't know the specifics of what we were trying to move. It stands to reason there would be some more discovery if the trial didn't move.
Excuse me, if you're going to have an answer questions, you're going to have the microphone, and you can use that microphone to stand because we can't hear him.
So he can be on mic when he needs to be on that mic when he answers you.
I don't know what you want me to do. Which one do you want?
Give that back to Jonathan and use that mic.
Okay, all right.
We weren't sure if this one was even working.
Okay, let's cut to the chase here. You asked Judge Kyle to let you continue to do discovery and take depositions until September, correct?
Again, I'm not sure. I did see the part you highlighted in there that said that the discovery deadline had already passed, and if the case was going to continue, if it was not going to be settled, certainly the parties would be interested in doing some discovery. So yeah, I'm sure that was part of the request.
Okay,
beyond the paper discovery that had been done.
Which defendants would you have deposed if Judge Kyle had given you the extra 6 months? Would you have deposed John Stromer?
Yes, because a lot of what he wrote is favorable.
Well, then why didn't you depose him during the calendar year 2021? You had 12 months to depose him.
Yeah, that's true.
All right. But you didn't get to depose anybody because on February the 22nd, about 11 days after you asked for the 6-month extension, Judge Kyle turned you down, and he refused to move the trial from May to December, correct?
Initially, he did kick back the 3-party request. Well, it's more than 3 parties. There are 3 main sides, Pope, Taylor Morrison, and Sandoval. All had filed a joint request that the trial date be moved because it was unworkable with what had been going on and the focus on settlement. And so the 3 sides made that request to Judge Kyle. Courts are under a lot of pressure now to move their cases along after the COVID backlog, and he did kick back the request initially. I think it was on a technicality that a request like that has to be signed by the clients. And so we sent it back around and gathered signatures from all the clients, met with Judge Kyle again, and he indicated, I think in an order that was entered, that the trial date was moved, the previous trial order was vacated, and that the parties would have an opportunity to submit a new case management plan.
Okay. Now, I've got Judge Kyle's order here of February 22nd,
where this matter is before the court on the parties' stipulated motion to extend case management deadlines filed on February 11. The court, after reviewing the motion and otherwise being fully advised in the premises, it is hereby ordered and adjudged that the stipulated motion to extend management case deadlines is denied. That means you're not going to get 6 more months to depose people, and you're not going to move the trial date from May to December. You were headed for trial in May, right?
No, that's not correct. He actually did vacate the previous trial order and indicated that we would need to pick a new trial date in a subsequent order entered soon after that one. Like I said, he kicked that one back because he wanted to see that the clients were all informed and signed off on the request, and they all did. Sandoval signed, all the Taylor Morrison people signed, the Pope people signed.
Okay, after this, Judge, the order that I just read you from Judge Kyle was on February the 22nd. On 6 days later, on February 22, after Judge Kyle denied the extension, Sandoval's board was called into a closed-door executive session regarding a legal matter. Do you remember that?
No, not specifically. Was I a part of it?
That was my next question. Were you there?
I don't think that I was. I mean,
You were not.
okay.
All right.
3 minutes.
3 minutes.
I allowed him a little bit more. I'm sorry. I really do want to hear him, everybody. I want to hear from everybody their questions and concerns tonight as best as we can. I think that's fair for us, and it's fair for you, and it's better than putting things out on Facebook one-sided. Okay? So, go ahead.
Thank
Go
you.
ahead.
I think I heard John say that you guys did meet on February the 28th.
Not everyone on this board, but the previous board, yes.
Yes. John Elkins wasn't on the board. Stan wasn't on the board. I don't know if Marilyn was present at the time, but suffice it to say that on February the 28th, the then existing board got together to consider a legal matter, correct?
Correct.
Okay. Now, it was at that February 28 executive session that the board decided to go ahead and take title to the sales tract in settlement of the lawsuit, correct?
I don't know.
Correct.
I think they do.
Okay.
Okay. And was it at this same February 28th executive session, closed door, that you agreed to pay attorney's fees in an amount that had been negotiated with Morgan & Morgan?
No, that was not discussed.
That was later. Okay.
No, it was earlier.
Earlier. All right. And neither you nor any member of your firm, to your recollection, attended the February 28th executive session?
Not as you described it. I don't think I was there or anybody else.
Okay. Was Mr. Spooner the only lawyer in the room for that?
I think so.
I don't know.
You can't answer.
Grady's shaking his head yes. I'll take that as an answer. How much, because we didn't get cash settlement, you guys appropriately negotiated a fee for your services as a firm, correct? Because it wasn't a cash settlement that you could apply a percentage to, you had to negotiate what a fair fee would be, correct?
Yeah, I see what you're getting at. Sure.
Okay, sure, okay. How much of your firm's negotiated fee remains to be paid?
Actually, we haven't realized any money from this yet. We do have some money sitting in trust. Some of it was paid by the defendants. Some of it, I think, was Sandoval's cost retainer paid at the beginning of the case that was to be held until the end.
As I recall, we deposited $25,000 against out-of-pocket expenses.
Right.
And then you got $25,000 from Pope, right?
Yes.
Okay. How much was left? How much do we still owe you? How much cash are we going to have to come up with to pay the negotiated fee?
So some of that cost retainer was depleted. It was depleted 5,000 and change, something like that. So we have 45,000 in trust now. We have not banked that as fees because we're still talking with Sandoval and trying to be very nice to the community in terms of terms. I don't know if the board wants me to address the the specific amount or those kind of discussions that are going on, but Morgan & Morgan wants the community to be happy with the result to the extent possible,
Well, these are the folks here whose assessment dollars are going to pay that fee. Don't they have a right to know how much we're going to have to pay?
Go for it.
Is that okay?
We're still discussing, but yeah, go for it.
Okay.
We haven't settled. We haven't settled on it yet. We're still discussing.
I just wanted to make sure that it was
But
okay with the board.
there is a number.
So, under Morgan & Morgan's fee agreement, there are, I'm not taking your time as far as I'm
Yeah,
concerned.
go ahead.
Under Morgan & Morgan's fee agreement, there are certain tiers. Once you get to certain milestones in the case, the contingent fee goes up accordingly, and it's different for every case. For this particular case, there was a 40% tier based on how far we got into the case. Actually, there's a 45% tier once you get within 150 days of trial. I think that's the final tier. So once you get within 150 days of trial, it goes up to 45%. The one below that was 40%. Because the judge in his second order, which I guess isn't here, because the judge in his second order moved the trial date indefinitely and vacated the previous trial order, and it would need to be reset, I applied the lower rate, or I should say I convinced the firm to apply the lower rate.
Which was?
40%. In terms of the property value, it's subjective. Like I said, there was an appraisal at $600, a broker price opinion at $625, another one at $750. I think the assessed value is like $550.
$535.
Yeah. Okay. So, and those tend to be low. Not always, but they tend to be. So our discussion with the board was based on a $600,000 kind of valuation. That was thought to be conservative at the time. So 40% of $600,000 is $240,000. And I went to the firm and I said, well, can we give them a little break on that, particularly if the payments rate is made reasonably soon? And the firm said, okay, we'll do $200,000 instead of $240,000.
40% of $500,000.
40% of $500,000.
Okay, so $200,000.
And the board has asked for additional terms, extending the payment out for actually many months, and that's part of what we're still talking about.
Okay, but how much of that $200,000 remains to be paid?
Well, if we and the board sign a closing statement that allows us to bank the money that's there now, call that $45,000.
Which is the plan.
So it'd be another $155.
Thank you. That's all I have.
Scott D. Philippus.
Good evening. Sorry. Scott D. Philippus, 2612 Stony Hill Court. I think Mr. Hiller covered some of my questions here, but prior to the HOA receiving the property, was a survey done?
I don't know. One of the things the board was concerned about was environmental on the property, and so they did order an environmental report. And I don't know what else was commissioned. I don't know if there was a survey.
Okay. Was a property inspection done, i.e. the building, aside from the environmentals, done by a licensed inspector?
So we had both legal and real estate professionals on the board who went and took a look, and there was talk of hiring a commercial real estate inspector. I don't know what happened with that specifically. My advice was always that Morgan & Morgan doesn't do real estate law. We don't do tax law. Any of those issues are going to have to be discussed with regular counsel. Do whatever due diligence you want on the property, and they certainly did some of that. I don't know the specifics. It would have to be something they would have discussed with regular counsel. I do know, and as far as I'm concerned, I'm not taking your time right now either. I don't mean to filibuster you. I do know that one of the concerns with any form of settlement was the tax implications of it. And again, it actually says right in our fee agreement, we don't give tax advice, so I try and stay out of it. But I listen when people are concerned about these things. And there was concern that if you do a cash settlement, which Taylor Morrison wasn't even offering, but let's say you do a $500,000 or $600,000 cash settlement with them, there was concern among some of the people involved that because that money could be construed as cash paid in lieu of assessments, deficit contributions that should have been made back in the day, that it could be taxable as revenue to an HOA. And HOAs get hit hard with tax liability. Someone told me it was 30%. So, yeah, it is? Okay. So, so there was concern that if we do a cash settlement like that, by the time you pay Morgan & Morgan's contingent fee, by the time you pay our experts' fees and litigation costs, which were poised to really start taking off, both categories. I mean, we could have deposed a bunch of people. I think the settlement value would have gone down if we had, but in any case, it would have run up costs, a couple grand at least per deposition. Accounting firms can eat up that cost, $2,000 over a lunch. So there was concern if we do a cash settlement, by the time you pay taxes on it, pay our fee, pay the experts' fees, pay the litigation costs, there'd be very little left. And it was thought, and again, I'm not going to tell you this is right because it's outside my practice area. There was a thought that a property settlement could be treated differently because essentially what you're arguing is they're just giving back property that shouldn't have been taken out of Sandoval to begin with. And so you might be able to get a little bit better treatment tax-wise on that kind of settlement. I hope that's helpful.
It is, and being a previous board member and kind of like the infancy, I do have some knowledge about that. But a couple more questions. Does the board know if a property inspection by a licensed commercial property inspection has done since we've acquired the property?
Yes.
Thank you. How was the property conveyed? And I know it was through a deed, but okay, as a realtor, what type of deed was it?
It's a quitclaim deed.
Okay.
So they weren't made any warranties.
Okay, so as a realtor, we're, as John will say, we're charged with taking our core law classes to carry our license. And here's just something that I kind of dug back into my paperwork. And it says, however, unlike a warranty deed, a quitclaim deed does not provide any guarantees or warranty that the grantor, TM, has good, valid title to the property. Yes. Because of the lack of a guarantee, a quitclaim deed in Florida is typically used to transfer real property to a family member or to and from one's own LLC. So as a realtor for 8+ years now, it really raised hair on the back of my neck that everyone here would acquire a piece of property that we have no idea if there are any other liens or anything on that property. So that to me raises concern, and there might be a legitimate reason why. You're the lawyer.
Can
I'm
I address
not.
that?
Absolutely.
Okay. So that's a fair point. Taylor Morrison did, as a matter of contract in its settlement agreement, they did represent that they're the owner of the property and that they have full right to convey it to Sandoval as part of the settlement. There was concern among some, for example, that the broker that Taylor Morrison had to fire in order to convey the property might be upset and might expect some kind of fee. If that's the case, then Taylor Morrison has breached its representation, has acted contrary to its representation that it had full legal right to transfer title. And so far, we haven't heard of any issues like that. So I know that was a concern. But they did warrant, at least in the settlement agreement, that they had full right to convey the property. And the board, in fact, as part of its due diligence looking at this settlement situation, the board was able to obtain some title work. That
an attorney's opinion of title, which is what we got.
An attorney's opinion of title is not digging in and finding out everything on there. So that piece of paper is invalid.
Yeah,
it really means nothing.
I'd have to show you what it is.
Yeah.
You might be satisfied with it, you might not. I think it was
true, but again,
I think it was Fidelity that did the research on the property and determined that the original loan to acquire it had been paid, that the money that had been owed by the previous developer had been paid. They weren't showing those kind of encumbrances. There's assessment type type things, including water and sewer. I know that's a topic of concern, but
it just, for me as a realtor, number one, and as a homeowner here, I wouldn't want any more exposure to the residents or myself, and I would have never accepted a quitclaim deed from TM. But that's, again, I'm not a lawyer, but that's just my opinion. Now, before the property was accepted through a quitclaim deed, was anyone charged with doing a cost analysis of the property prior to the acquisition, such as carrying costs, taxes moving ahead, and our ability to pay that once the board accepted the property? Because I see after this is Mr. Ciganek and Mr. Rinehart are going to talk about due diligence financials, and if any two people can come up with the correct numbers, it's those two gentlemen. I trust them emphatically. But again, to accept something through a quitclaim deed, not knowing what our costs going forward are, is, I think somebody did not do their fiduciary responsibility, to use that phrase. So I think it was a disservice to the residents, not knowing moving forward if we have an acquired asset that could be a liability or to the HOA. So
in response to that, I would just say that there were those discussions. I was involved in some of those discussions. I knew that it was something the board was talking about. I wasn't in their closed sessions where they're talking about the litigation and the settlement. So I can't speak to that, and I really can't speak to the specifics of what I discussed with them because those are privileged communications. However, I will say that it is something that was on the radar, and they were aware that there were water and sewer hookup situations and things like that.
Because moving forward, previous board members, my being one of them, and being involved in the community on different boards, we all knew that double wide trailer that on there was temporary CO. It wasn't a permanent structure. It was on well and water, or well and septic. And we knew there were deficiencies in that building, and there probably still are. So that building is probably a tear down. So what really did we get out of that? A piece of land that could cost us a special assessment? Personally, I don't gamble, but I would have rolled the dice, because when you guys first came and I was a board member, you guys kind of touted that $7 to $9 million settlement up north, and I was like, wow, that'd be pretty good for us. And now we're looking at owing you guys $200,000 for a piece of property that could be a turd. So, thank you.
Thank you, Scott. Mr. Robertson. Rich Hernandez. I did. We have another presentation to make, so if I allow you the questions, we're all going to stay together. Nobody's going to leave early.
Scott already took one of my questions. Rich Hernandez, 2546 Greendale Place. Hello?
Yeah.
Our new asset has public access to it unlimited right now. At this time on the outside. It has become a popular place to drop off kids or pick up kids going to school. Okay. Doesn't this increase our exposure to greater liability for insurance and insurance expenses?
Do you want to answer that?
Rich, to answer your question is yes.
Okay, that's it.
However, we were able to insure that property under our existing general liability policy, which the carrier has graciously granted us. So we do have liability coverage on that property through our current CGL policy.
Thank you.
Thank you. Charles Ponzo?
Good question.
Mr. Ponzo? Yes. Oh, sorry. Thank you.
Well, I'd have to say that you've probably addressed most of my concern, and it leaves me with just one last note, and if you just give me the courtesy of 1 second to check my notes. Very sorry about this. I know time is of the essence, and I don't mean to take more than... Well, there was a question that I don't think was answered. Ms. DeFilippis asked it, and it was, has any estimate been put on, has the board gotten together with any estimate of what this cost is going to be with attorney fees in excess of six figures?
And that's the second part of tonight's presentation.
So that's going to be answered.
Part of that, and then when we have our
So unfortunately, I can't address whether I'm pleased with that answer or
after
not.
their presentation, you may address it.
Okay.
Another question and answer
Okay, then
session.
that handles what I'm looking for, because the other thing, which I assume is going to be part of that, is has the board thought of how the payment is to be made for these things? Where are we getting the money?
Right, we're still discussing it. Yes.
Oh, it's under discussion? Will that be presented this evening?
No, we haven't finalized anything.
Okay.
Thank you. Ms. Chaplin, Kathy?
Wait. Oh, he's going to the bathroom.
Yeah, definitely.
Yeah, I think my question's more after their presentation.
Okay.
So could I?
Thank you. Yes, definitely. I'll keep you. Ruthie Marzullo?
First.
If it's okay, I would like to give you my
Oh, I didn't even text you. I didn't see you there. I'm sorry.
Hello, everybody.
Hey, Brian.
Yeah, I wasn't expected to be back here so quickly. I just wanted to follow up a little bit, and most of my questions are going to be directed to Jonathan. After all the hours of research, is it fair to say we were basically left with the surplus claim?
I think that's the real meat of the case for sure. I think if we would have lost that misuse of the surplus claim, it would have gutted the case.
Was the surplus claim a slam dunk?
No.
What would have the costs been to proceed to trial? Experts, depositions, prep, hard costs for Sandoval that we'd have to pay out of our pocket?
I think the accounting experts, despite my constant efforts to rein them in, and I know Sandoval had to write some checks to them along the way, taking them through trial with testimony of premium fees and such, it would have easily been over $100,000 just for the accounting experts. All the related costs for transcripts, from hearings and depositions and all that kind of stuff. Costs could approach $200,000 through trial.
And that comes off our end, not your end. Is that correct?
It does. The attorney's fee is assessed first, and then the costs come out of Sandoval's portion of the recovery.
What if we lost? What is the downside risk if we proceeded to trial and lost? Were there attorney's fees, expert fees, defense fees that we'd have to incur? What's the risk to the community?
Well, when you make a claim for attorney's fees, or if there's a basis for attorney's fees, as there was against the Taylor Morrison directors, under Florida law, it generally works both ways. And that is, if you win, you get them. If you lose, you pay them. And so in the event of a loss at trial, Sandoval would have, any costs advanced by Morgan & Morgan, we would have eaten, because that's the nature of our deal. For this particular engagement, Sandoval was paying a lot of the costs, though, and that's why the retainer was paid up front. So in the event of a loss, you essentially end up losing all the costs you've paid along the way, which could have been anywhere from $100,000 to $200,000. You're going to pay the opposing party's costs, which could be a similar amount, upwards of $200,000. If you have to pay their attorney's fees, that's huge, as you can imagine. That could easily be $500,000 that you'd have to pay to their attorneys. And so the cost of potentially losing a trial is huge. It could be a negative $600,000 or $700,000 or $800,000 situation.
What about the cost associated with the lawsuit in Sarasota? How much could that have cost us?
Well, because it's a defensive case from Sandoval's standpoint, Sandoval was sued up there by Pope Properties under the contract. A contingent fee agreement doesn't work for that, so you have to hire hourly counsel. I don't want to speak for Becker Polyakov if that's who you use for something like that, but I wouldn't be surprised to hear that they're charging, $400 plus for that kind of litigation. And, to defend a case like that, if it goes the distance, could easily be six figures as well.
Is it true that maybe we could have gotten an easier settlement, a little bit of cash instead of the sales center, but gave up our claims for phase 3?
I don't know. Taylor Morrison was very consistent with the we aren't paying anything. The cash was supposed to all come from Pope. It ended up Taylor Morrison did have to chip in a little because Pope was obstinate. But I do think that if the board was willing to let go of the phase 3 claims that were carved out and have been preserved and you can still pursue, I do think that would have been worth quite a bit. It's hard to say how much. I still don't think they would have paid over 100. I don't know. It's hard to say. From your perspective, those claims are valuable, though.
Is it fair to say that this board was not offered any cash settlement that did not include a phase 3 carve-out? In other words, we did not have the option to settle this for cash and still preserve our phase 3 claims. Is that accurate?
Yeah.
So it was either proceed to trial, take on all these risks, defend this Sarasota case on top of it, or settle with their option. Risk, benefit. Most importantly, do we all know what the phase 3 claims are? The folks that live in phase 3, are we willing to sell out phase 3 because it's easier for us? I don't think so. John, in terms of the valuation of the property, it was my understanding that we were looking at the value of the property, not the dwelling, when we did our analysis. Is that accurate?
We looked at both.
We did look at...
Because in commercial real estate, you look at highest and best use. And Scott, you're right, it is a manufactured home, but it's a triple. And they did refloor it, some things. It might have some use. And looking at the highest and best use of it as it is now, it could be a doctor's office or whatever. But it would require, well,
John,
there's a whole new group going to get together in terms of what to do with it.
John, but it's under a temporary CO, and the city has said they will never grant a permanent CO to that triple wide.
Is there any question that the real property is worth below $400,000? It's never been presented to me. I was always told by the real estate experts that the value is the property. We're getting caught up on pipes of this temporary dwelling that we all know is in disrepair, but the value is the property. And in our evaluation, that's what we looked at. Just a couple more questions and I'll be done.
Yeah.
How much does it cost to take a deposition?
Well, it depends on if the transcript's ordered and what time frame you give the court reporter to order the transcript. It seems like nowadays even if you don't order the transcript, the typed out version of everything that was said, it's hard to get out of those things for less than upwards of $1,000. And if it's an all-day deposition and you need the transcript fairly expeditiously, you can pay $3,000 or $4,000 each easily.
How often are these depositions quashed?
There are always fights about that before a trial. Each side gets an opportunity to designate the parts they like, and then you have a hearing in front of the judge, and he decides what, if any, use is going to be made out of them. The use that you can make out of them is often minimal, unless someone shows up and decides to contradict what they said earlier, and then you can try and impeach them with it. But a lot of times it's not a great investment.
So did you feel like you hurt the case by not taking a bunch of depositions 6 to 8 months before the trial?
I did not. The parties were focused on settlement, and I was confident that we'd be able to get that carve out that we had been trying for, that we ended up actually getting in the end. There was going to be more time to do those kinds of things, but like I said before, in my judgment, this, like I said, there are cases where the farther you get into it, the more stones you unturn, the better it is, and this was the opposite of that.
My question's for the board. Do you all realize your responsibility to do your due diligence and pursue all claims associated with Phase 3? Do you understand the significance of that? And if there are claims that we're going to need to retain counsel, preferably on a contingency basis?
Yes.
And that our relationship with Morgan & Morgan is important also?
Yes.
You do realize that? Just a couple other quick things, and then I am done and out of here. You know, just a brief history, we voted, in order for a HOA to sue somebody, you have to get a community-wide vote, pretty rare and pretty hard. Well, we were all told back, and Dave, you'll remember this, 2018, that we had a contingency fee agreement. We voted on this, and we proceeded to sue Taylor Morrison. Well, I came on the board in March of 2019, and I discovered we spent near $80,000 in Taylor Morrison litigation. How'd that happen? We didn't have a contingency fee agreement. When the board sat, we worked very hard. I worked with Dave, and that was in 2019 of May, we got Morgan & Morgan. There weren't a lot of options out there. Since then, we worked very hard and worked up every single claim and saw what was there. We followed every lead to arrive here and to do the risk, the benefit. Thank you.
Thank you, Ron. Anybody else that wants to talk to John? Nope, just, okay. Are you on the list? Oh, okay, I'll get to you.
Eric Blythe, Hopefield Court. The only concern I have is moving forward. I happen to agree with the settlement that the way you described it. I'm not happy about it, but I happen to agree with it. I mean, that's probably the best we could have gotten. But moving forward, I can't speak for my fellow residents, but from my standpoint, I want to be able to be involved in what your decision is before you make it and saddle us with a bunch of fees. Can you commit to that you'll let us know and keep us involved in this thing?
Absolutely. I stated in my opening that we are going to have a workshop in May.
Right.
We're going to discuss it further. We have the question and answers tonight, and in June we're going to hold a vote. The board has the right to make that vote. We don't have to put it out to the community, but every member here unanimously wants everybody's input, so it is going to resident vote.
Okay, that's all I care about.
Okay.
Just briefly on that point, when you're talking about settlement negotiations, and particularly if it's in mediation, but just negotiations in general or discussions with counsel, there's a certain amount of secrecy that just has to be maintained. Otherwise, you end up waiving the attorney-client privilege. And then it just opens the floodgates for them to look into all sorts of communications with the community. So there necessarily has to be some of that, but I can totally appreciate where you're coming from on that. Are there any other questions?
There is one more.
Okay. I'll just say something briefly when they're done.
These are for the finances. Yeah, I just asked. You're welcome.
Thank you, President and members of the board. I have a very simple
question. Your name and
Oh, I'm sorry. I'm Jack Pounds. I live on Verdmont Court.
Nice to meet you.
I'm interested in Hayden Lane.
Just, you can take.
See your doctor. Okay, so finally we engineered that. I have a question about Hayden Lane. As I understand it right now, Sandoval is responsible for the maintenance of half of Hayden Lane, and the other side is the fellow that owns the Surfside shops. Is that Hayden Lane ownership, will that be transferred if we ever sell this property that we now own, or will that continue to be?
I haven't heard that. I have not heard. That stays ours, as far as I know.
Separate deed. Yeah, it's a separate parcel. If that piece of property had gone to someone else, we would still have
Okay, so we'll still have Hayden Lane regardless.
That's my understanding.
Okay.
But we'll look into it.
Well, there is a cost there, and I was just
sure.
wondering if that could. Okay, thank you.
Can we take a 5-minute break and then we will disperse so they can get ready for their presentation because I need to move. Sorry. 5 minutes.
So I just wanted to thank everyone for coming out and answering questions and participating in this meeting. I expected to take some shots. Some of you got in some good ones, and that's fine. That's fine. I like the process. I fight with people for a living. Litigation is psychological warfare, and I prosecute each case differently. Some cases you work it up the sort of traditional way. You serve your paper discovery. You notice a whole bunch of depositions, and you just lock horns and go that kind of traditional route. In their mind, we had Taylor Morrison in a very bad spot in this case. The way we had it postured, they felt like they were in a very bad spot, and that's exactly where we want them to be. I like a lot of the discovery process. My favorite thing as a lawyer, well, I have two favorites. Number one is I love to argue in court in front of a judge because it's so satisfying to have the judge say, you win, you lose. I love that, and I love cross-examination. You can sort of do the Jedi mind trick on people, get them to admit to damn near anything if you ask the question right. And I enjoy that process. Some of you who are lawyers or who know lawyers know what I'm talking about. Cross-examination is fun, and there are cases where that can make a big difference. But again, it's psychological warfare, and each case is prosecuted differently. Sometimes it's a little unconventional. In closing, I wish that everyone were totally pleased with the way it turned out. I suppose that's unrealistic. It does make me feel bad that there are folks who aren't totally pleased with how it turned out. That kind of wears on me. What I really hope to hear at some point in the future, and even though I'm leaving now, I plan to be here for many years. What I hope to hear in the future is that you overcame some of these issues, and you got a nice resale of the property. You found someone who thought that 1.7 acres or whatever, with or without the structure, was just what they wanted. And I hope to hear that you sold it for $600,000, $700,000, $800,000, some nice number like that. It will never occur to me, if that happens, that our attorney's fee should have been higher. I am more than happy for the community to get that windfall, including as a resident. So that's what I hope happens. Or alternatively, I hope that you put it to a good use and people enjoy it. So it's been my privilege. Thanks so much.
Excuse me, sorry. Give me a second. Well,
Thank you.
you ready for me, Kathleen?
Yes.
All right. Good evening, everyone. I didn't run too many of you off with this part of the presentation, so I've got the mic on, John. Vic's got me. So once again, my name is Todd Rinehart, and with my fellow board member Dave Ciganek, we prepared this presentation this evening. As you probably know, David has been in the financial investment world for many, many years, and I've been a commercial banker for over 40, so there's a little bit of experience in putting this together. It's taken a lot of time and effort. This presentation is not a position statement. Rather, it's a realistic illustration of what assuming the sales center property will cost our HOA. As Kathleen noted earlier, there will be a town hall to decide the use, the sell, or whether to lease, and then it will go to the property owners for a vote. The first 2 pages of the presentation will basically give cost on what it will be to remediate the property. The second page will be what the operating costs would be on a monthly basis based on some assumptions. Bids have been obtained. These costs are good. Operational expenses on page 2 are what I would say directionally correct. There's some obviously guesses that are being made on it. The final 2 pages Mr. Ciganek will present are break-even points, profitability opportunities, and some sales assumptions. Again, reemphasize this presentation is for illustration purposes and is to kind of help educate you like it did us on where we're at. Questions in regards to my presentation, we'll wait until after David's, and then we'll be glad to answer any and all questions that you have. Publicly, for the record, I just wanted to say that I am the only person, the one person who did not vote for this settlement. However, in the spirit of being a board member, my fiduciary responsibility is to carry out the majority. So I have been put in task with David is to come up with a solution. And so that's why I'm doing this presentation. All right, we'll get started on page 1. And I'm going to go line item by line item. I'm going to go briefly, not briefly through each one. Go across the top.
All right, so here we have what we categories of estimated expenses associated with the property. Okay, these would be development costs. Todd will go through that. Then what we did, we got actual quotes and bids. Okay, and then we turned those quotes and bids divided by 12 get over the actual monthly. Okay, so when we say actual, we mean real. These are numbers that we got.
Don't confuse us with the red light if you're going to go all over.
Okay.
So why don't we go ahead and get started? I mean, we're already running late, but the first line item, you heard the discussion previously in the last presentation. At the end of the day, the legal fee to Morgan & Morgan was $200 gross. There's $45,000 in credits that are due back to that particular fee. So we have an $155,000 expense that we've got to figure out how to pay. I can't say it any better than that. As Scott DeFilippis mentioned in his comment, we took a quitclaim deed on this particular property. What does that mean? I'm going to use an analogy. I apologize to those that are dog lovers. We got the dog in the pound, and we inherit all the fleas. Okay? And along with that, that property has approximately $26,521.69 in betterment and impact fees that are due to the city of Cape Coral. Okay? The city of Cape Coral, betterment and impact fees, $26,521.69. We inherit that when we took the quitclaim deed. That's due to the city of Cape Coral. Okay? When you take a quitclaim deed, we were responsible for filing the doc stamps on the deed as well as the recording. That dollar amount which has been paid is $3,346.75. The next one, miscellaneous items, we left blank because we do not know what the closing cost or closing fees would be if there was a disposition strategy to sell. A formal property inspection was done after settlement. We do have that. It's very telling. There's no secrets. The property is in disrepair. A formal commercial appraisal has been ordered and engaged, and we anticipate having that report probably sometime next week. My comment on that is, would you ever use an appraisal from a seller if you were a buyer? We'll just leave it at that. Landscape remediation. This is an actual bid from Crawford. Cost is $18,669.93. That's from Crawford. That's an actual number. Sure. 93 cents. Don't forget the 93. The cost that it's going to cost us to remediate that property, bring it up to snuff so it doesn't look like an eyesore, $18,669.93. Okay? Yes, pretty much. Yes. No. Let me get there. I'll get there. Hang on. There's so many tentacles to this thing. I mean, I want to keep everybody in the game. Okay. So I talked about the commercial appraisal. We'll have that. That's a $2,300 expense. Landscape remediation, talked about that. There is no water, city water or sewer on that site. Therefore, if you do a hookup, it's approximately $2,500. Then you have to hire a contractor to hook it up. I got the bid from Haunch, and that is $3,000. You got to pump out the septic tank, that's $400. You've got to crush the septic tank and fill it, that's $1,500. That's honk. Contractor rehab, if there's a strategy and it's decided that we're gonna, as property owners, keep that property and rehab it, make it useful, that $100,000, don't laugh at me, that's grossly underestimated. That's $35 a square foot. Tell me anybody can do that for $35, and we'll let you draw your own conclusion. Legal fees in regards to Becker-Polikoff, is that Becker-Polikoff and is $5,261 to participate in the executive session process. Here's the interesting thing is the way that the property sits today, the utility hookups for water and sewer have to be redone. So whether we decide to use it or we decide to sell it or whatever, we have to disclose to an end user that they're going to have engineering plans redone in order to have the water and sewer reran. That's a wild guess at $10,000. $10,000. No, they got to redo the entire plan. As it sits today, civil plans have to be redrawn and have to be submitted to the City of Cape Coral for approval. That's just the plan. Just the plan. Next one. Here's one. Circle this one. I got a cost to demo the building. Level it, flatten it out, get rid of it, $22,900. Well, in all seriousness, Kathy Krieger has volunteered that if we have a flood, that she would take them off our hands if they floated down Veterans Park. So we'll keep her promise on that. You remember that. Somebody asked the question, Rich asked the question about liability issues because it is being used as a bus stop. I'll talk a little bit about insurance on the next page. Thanks, David. The signage required, this is an estimate. We have to put signs on that property that say no trespassing, no parking. Okay? You want to open up a hornet's nest? Put those signs on there. But our insurance carrier may be dictating that is a requirement. And there's a reason why on the next page. Municipal utility deposit, roughly $1,500. If we were to keep the building in order to obtain property insurance, we would have to have an Invera system or an alarm system at an estimated cost of $5,000. So there's some costs. If you add them all up, about $361,000. Pretty expensive. Anyway, and then at the bottom, if you were to take that number and divide it by the number of 1,425 units, it's about $254.02 per property owner. That if the board decides to do an assessment, that would be your cost. Go to the next page.
My computer. Oh, it's stuck. Would you believe
Let me just go ahead and continue while David works on that. You heard Jonathan talk about the legal ease of that property was cut out of the deck by Taylor Morrison when it was originally in the deck. I'm really going into the weeds here, okay? Well, if you leave the property outside the deck, we have to pay property taxes. One of the other functions of accepting a quitclaim deed, there's no formal closing, okay? What does that mean? We inherited the property taxes from January 1st through the entire year of 2022. which is estimated at $9,554.14. That's a true cost. We inherited that fleet. I apologize for the reference, but it probably understands. Thank you. Next one is property insurance. The quote, $2,475. That includes no wind, no theft. It's a basic insurance policy that has many inclusions. Vacant building is an issue, so much that the carrier that it was submitted to has declined to cover the building. So therefore, we do not have property insurance because we cannot find a carrier who will insure the building. Okay? Flood insurance, the flood insurance quote was $4,300 roughly. We've made a business decision, Kathleen and Kathy and with David and my input, that there's no sense in spending $4,300 on flood. If it floods, let it float away. Okay? Liability insurance, here's a real shocker. It's only $525. As I mentioned, that property has been included under our master CGL policy, which is our general commercial liability policy. And we're basically covered for $1 million per incident or $5 million under the umbrella coverage. Yes, that was a priority thing because you can almost, something's going to happen. Landscaping, if we were to keep the property and have Crawford keep it up for us, it's $682 a month or $8,185 per year. The rest of them are utilities. This is where I said it's kind of directionally correct. Gives you an idea of what we'd have to pay in operating cost. So, if the decision is to keep the property, we're looking at roughly a $3,700 month cost just in operational costs. That doesn't include the cost on page 1, which what it would cost to bring the property back up to speed. Okay? Yes, sir. I'll take your question. Then I don't have to answer at the end, right?
How many of these costs can be forced off to yourself if you decide to sell this property?
Well, any cost can be. I mean, the thing is that you have to do, as any real estate professional will tell you, you'll need to disclose the fleas on the dog if they submit an offer, right? What honestly has happened, you have to understand the business I am in, I have some kind of insider knowledge. The property was under contract 3 different times with Taylor Morrison. And what happened is when that particular prospect started digging into due diligence, they walked away. There's what happened. So to answer your question, Eric, yes, if we decide to carry forward the cost of the utility thing, et cetera, we just have to disclose. Here's what we found out. Here's what you inherit at that particular time. Yep. All right. Yes? No, $3,700 a month or $47,000 a year.
That's without electricity.
That's with electricity.
Well, that's with
yes.
these estimates, yeah.
Yep.
And estimated to fix up the inside or whatever it's used for.
Well, that was on page 1, which was $361,000. But I can tell you, if you cut and paste and you subtract some stuff, but you keep in mind that remediation cost on construction is grossly underestimated. So 361 is a good. It's a baseline to work with. Yeah. That's a decision you all have to make. I'm like I said, my whole qualifying statement, this is not a position thing. I'm just trying to give, we're trying to give, excuse me, an open eye view of what this is going to be.
Let me address your question.
Hey, I have
Everyone wants to know what a break-even point is. Where do I make money? Where do I lose money? We're going to do that.
He's going to do that in a second.
Okay.
Yeah. Marlene? No, you'll never know that. No.
Well, I can't go into it right now, but we are getting phone calls from persons.
I think her question is...
That have already put a contract on with Taylor Morrison. Taylor Morrison did not accept it.
So we may have some information. I'm not aware of that. Scott?
Is it not true? Is it true that an HOA cannot make money?
Not necessarily, Scott. We make money when we sell the headlight stickers. I mean, we pay taxes. I reported we had a tax return. We paid $5,125 in taxes on what? We have a lot of exempt income, but we do have some reportable income. And our tax return is available if you want to look at it, okay? And you can see what that is. So
in your professional opinion, selling land would be a permitted windfall under HOA guidelines?
I think what you're trying to ask is maybe, does an HOA serve as a good landlord or something like that, right? Do we have the capacity to kind of handle that type of thing? So that's the question that may need to be answered.
Yeah. Rick?
Is there mold in there?
The answer to your question is, based on the inspection report, yes.
Okay, it was just done visually?
There was there was no formal mold test because the property inspectors didn't see the need for spending the money to do that because he could see it visibly. Does that make sense?
Okay, so then I'm assuming it hasn't had air for a while?
I can't answer that. I don't know.
Okay, so we can assume that there is mold. You have to take air samples.
Yep. Yeah, no.
Also, my next question is Chinese drywall.
Yeah, I can't answer that, Rick. It is what it is at this particular point. We own the dog, and it just decide what we got to do. So.
Maybe to help answer your question on our first sheet, under the remediation contractor rehab, we actually identified some trades that would need to come in, which was part of the inspection. So you could take a look at that. It's the large baseline inspection to address the meeting. We have multiple trades: electric, heating, air conditioning, plumbing, wood framing, sheetrock, stucco. There's mold remediation, flooring, and we need a contractor to kind of wrap all that up.
Yeah, we don't know what we got.
So it's part of that.
Hold on one second. John, I'll give you in a second. Yes?
Okay, my question is, do we have to develop this project? Does there have to be a structure on this property?
No.
I mean, and is there an advantage? Just tear it down and turn it into a green space and in some way recuperate some of our costs?
I can answer that from the standpoint that I think once we have the formal appraisal, which is being done by a local Lee County commercial appraiser, that will give us, with the terminology in the business, the highest best use in commercial. They'll tell us exactly what the best use of that property is as it stands.
I know there was some concern about who we'd sell it to. We don't want a tattoo parlor there. We don't want whatever. So, the advantage,
Who would control?
the property, we maintain the property. Again, thinking in terms of like green space and somehow using that, would that reduce any of the costs that we're
Sure. If you just kind of you lose all of basically the except for the taxes and insurance, you lose all of the operating cost.
Is there any advantage, tax advantage to having a green space?
I can't answer that at this point. Let me move on. We got
one.
You promised one.
Put the mic. Yeah.
Okay, can you hear me out of this? Why don't we just pay for it to be landscaped, made pretty, and sell it as is?
We're going to discuss that.
Yep, that's part of the plan. John?
Yeah, my question is, and you probably have already asked this, but since Taylor Morrison has avoided doing all the fees, for impact fees and so forth, could we also avoid it and not spend that money and sell it as is?
Yeah, that was the question.
Yeah, I know, but there's some, and further, if we surely shouldn't attach plumbing until you know what their plumbing is going to be used for. So
right.
You wouldn't have that expense yet either.
But the purpose of this exercise, John, was to show a very conservative approach on what the costs were.
Totally understand.
But I think as any real estate professional will tell you, the more fleas the dog has on it, the harder it is to sell.
Sure.
Yep. Marilyn?
Yes, I am following this. These are all building costs. I really don't think the $155,000 that we have to pay to Morgan & Morgan should be considered as part of the building cost, because we have to pay that no matter what happens. And it's not part of the cost of the building.
Okay.
Well,
but what
let me ask.
Hold on. But what we're trying to demonstrate is
exactly
what do we have to pay for at this point? And I'm not disagreeing with you, but that $155,000 is not disappearing. We've got to figure out how to pay that some way magically, okay? Kathleen's working and trying to negotiate a deal because use some common sense. When do they want their fee? Yesterday. And if you think about it, we have a 2022 budget that was adopted, right? This isn't, you just can't pull it out of the air. There's been discussion, well, why don't you use reserve dollars? I'm not going to get up here and propose that. And we've also received some type of legal thing from Rob Cave saying you can't really do that in this case. So
well, actually, his comment was that he didn't recommend it.
He advised
and
that we don't.
The question I would have is that why did we pay back the loan from the operating fund for just over $1 million back into reserves? Why didn't we pay just a portion of that and keep the Morgan & Morgan funds, that $200,000? Why didn't we hold that and pay Morgan & Morgan? Dave transferred all the money from the operating fund into the reserve account and didn't even consider that that would be an option. This could all be very simple. I appreciate that you're getting into the facts, but I'd really like for both of you to stick to the facts and not the color commentary. You're exacerbating a difficult situation, Todd. I understand that you're offended and that you feel like you've been blamed for something.
No.
Let's move on to Dave's presentation, please, and then we'll take more questions, please.
All right, so we had some questions as to why don't we just sell it? Why don't we just sell it low? Why don't we just sell it high? So what we've done here is taken the figures from the table 1, which is the cost associated with the settlement. Okay, we kind of put this together as what is involved with this settlement. Okay, so settlement is the fees and all these other costs. So we built these numbers in and we said, okay, here's a gross sales price if we were to do 300 and so forth down. The second one down is that actual number. I put that in there so we could have that right out there. Okay, so when do we recover $361,974? And what do we need to sell for, okay? So it's a simple math computation, but we have to go to the middle of the page, okay? Anytime you're in a real estate sale, of course, we're going to be talking about real estate commissions and maybe some assorted closing costs. We estimated those to be about 10%, which we think is reasonable. When you have a real estate sale, it's about 10% total. So we broke that up into 6% on the realtor side and 4% on the closing side. And we identified those costs, which are in the negative columns. So if we look at, well, gee, why don't we just sell it for what the money that we put into it, $361,947, we actually lose. We lose $36,197.44 because we had to pay those costs. So the next line down, 400, oh, maybe 400, we still lose. So we're not guessing at this, we're actually arriving at this mathematically. And we come down to the 402,193.74. So sure, we get a gain before sale, but we pay those, notice in the total real estate and closing costs, that's our break-even point. So if we were to assume in this model that the cost of this settlement is the $361,974, or whatever number you want to come up with, we could compute the break-even point and answer some of these questions. Let's turn it into green space. Let's turn it to that. Let's walk away. Let's make money. Let's not make money. Let's clear out of this and break even. So this is the type of analysis that you would go through, okay? So that's why we put this up, okay? So this is really recognizing the fact that we're going to have settlement costs. We want to clear those costs out. We haven't said which way, okay? And we can actually compute a profitability screen here for you. Question? Well, I'm not following because then that money's gone because, yeah. Well, this is assuming, in a sense, how do we recover our money, okay?
Dave, I really need you to finish the presentation.
Okay. So let's go to the next screen. So we looked at, how about if we lease this out? Okay, and how about we lease this out, still paying the settlement cost up front, okay? And what do we need to recoup the money that we put up there over a period of time. Now, it's very much arbitrary with the time period and the interest rate that you want to choose. But I just, for the illustration purposes here, we took second column, bringing back to 361,974 payable at 0%. We're kind of borrowing against ourselves in a sense. Over a 10-year period of time, we need to pay $3,016 somewhere to get that money back. You follow that? We're paying ourselves back. That kind of answers your question, maybe. And then the lease operating expense, that number is picked over from table 2. We already had that number. We add those two together, we say the total reductions then of a $3,000 lease is we're losing $3,773 if we were to lease for that, okay? Now, as you go down on lease payments, you may go up on the quality of a tenant maybe. You know, that may be something to think of. So where do we reach a crossover point? Well, $67.73 is what we would need to break even. Paying ourselves back monthly. I don't care what, you give me any amount of months' time, I'll compute it for you. Okay. So this model could be fine-tuned. I put the calculator there that we used. I don't want to click on it because it would bring us to that internet screen. But we do this using credible sources to calculate the numbers. All right, so the next screen, we said, we're still going to do the settlement costs, but we're not going to borrow from ourselves. We're going to find somebody out there and borrow the money. So we're going to go to a source and lend us $361,947.37. Now, there's no loan guarantee at practice. Probably would be very hard, and Todd could address this, for an HOA to go out and get a loan because you have to have some standards in order to pay back the loan. Correct, Todd?
Yes, sir. Okay.
So we did the same $3,000. Now we need to recover on that loan at 5.5% over 10 years, and I put the interest, all that kind of stuff over there, $39.28. We need more money because we're paying interest. Now, let's do it over 5 years. Well, that's just going to balloon to a bigger number, okay? So we still need the lease operating expense. At $3,000, we're still losing money. We're losing more money than the rent that we're getting. Our break-even point is now $76.85, okay? So this is purely attacking this from a money standpoint. Where do we break even? No matter how much money you want to put into it, we'll calculate it for you, okay? You want to delete categories, add categories, mix them around, do whatever you want to do, fine. Some of these cash flows may be more immediate than others, particularly the fee. We already brought that out, okay? So, but in the long run, when you look at the big picture, this is the money that's going to be coming out of our accounts somewhere, okay, on those settlement costs. So, we want to use this as a tool to answer questions because you guys and the board and the people watching are going to decide what happens here, okay? So we want to be able to give you this information, useful information. So you can sit down, think about it, and say, hey, Dave, what about this? We're going to be here answering those questions for you. Any questions?
Wait. I've got a list here. I'm going to go by the list first.
Okay.
And then I'm going to get everybody, okay? All right, so I'm going to go back to the top. Mr. Hiller, did you want to address?
No, I'm good.
You're good. Okay, Scott, any more for you on the finance session? Okay. Mr. Robertson?
Yes.
Question?
Can we go back to the first page, please? So that's $361,000. That $361,000 is a total cost if we do all of those items if required, including the $155,000 that we've got to pay Morgan & Morgan. So if there's a reno of $100,000 and a demo of $29,000, we're probably going to choose one of those two.
Exactly. We're going to be talking about options, but we put it all up here, okay? Remember, this is a model.
And without saying who the person was interested in purchasing it, I'm assuming they know what the land looks like now.
Some of them do. There have been a few people.
If they were a previous buyer, they know what it looks like now.
Yes.
Okay? We don't need to know who that is. Maybe in May you might be able to disclose that if it's something that's important and we want to know who we're selling to as a community. Which means all of those costs won't necessarily be incurred, the $361,000, if we can get $500
we know we gotta pay the 155 as being the way we wash that. Then the other costs that we have, we don't know what they will be until we get to that point. You're not gonna pay for a whole year of service if you're not servicing.
Remember, these are one-time costs.
Is that a correct assumption?
These are one-time costs, not monthly. Table 1 is come up with the money. And I wouldn't be surprised if a buyer has a list. The same type of thing, okay?
Yes, but they already know what it was before, and I'm assuming Taylor Morrison wasn't doing all of those things. And just from my own personal knowledge, the impact fee, does that actually take care of the total impact fee, or is that an annual go-forward fee?
That's a one-time fee. Oh, sorry. That's the one-time fee due to the city of Cape Coral for
And do we
water
know
and sewer.
how it's being paid today?
It's not being paid at all.
Because it hasn't. So it is something that is negotiable with the purchaser.
Correct.
Oh, yeah.
So like I said, there are numbers in there that can work around. Now, the other question would be is, if us as residents choose that we want to keep the property and make it something worthwhile, $3,700 a month is approximate cost of what it would cost us. Based upon whatever we do with it would incur additional costs.
After you pay this.
So if we wanted to keep the property,
You paid the $361, and then you have to lease it according to the table on the next page.
my next question is, can we borrow from ourselves the reserves and get rid of the 155 from Morgan & Morgan, so make sure that we do not incur any potential interest charges? And then we would have to build it back in to the budgets over the next coming years if we wanted to, or just right into next year's budget, because this isn't really going to get settled much before the end of this year.
You know, any outcome could be analyzed, and if you want, the impact against reserves,
the question was,
you have to very carefully analyze that. We're going to be doing a
Can we
risk
borrow
study.
from ourselves the reserve with intent to pay it back and make sure we don't incur any interest if Morgan & Morgan decides to put us on a payment plan?
We're still working on those details.
Okay, but that
Ron Caves advised, because I'm still looking into all those options, I'm still trying to get legal questions answered about how we can, where we can do it.
and I think we need to go through with that. But the question still is, can we borrow from ourselves?
I think we answered twice, and I'm going to say it a third time. Still working on it, but we were advised that we should not withdraw from reserves. Oh, I'm with that, sorry.
Can,
To answer your question specifically,
you're off.
Yeah, you guys wear microphones so you can
It's mine on?
You ask a good question, and one example of an answer would be we have borrowed from reserves before. As I mentioned earlier, Dave Ciganek transferred funds from operating back to reserves. We had borrowed from reserves previously. Our attorney did say he wouldn't recommend it. He did not say not to do it. We do have these funds available. We can do exactly what you've suggested. Is it the best thing to do? We haven't determined that yet.
Can you hear me?
But the answer to the question is yes, we can.
If the decision of our residents,
we can.
if our residents decide to sell it, okay, and it's up to our residents, my opinion is we should do it as quick as possible because it reduces cost. Also, I would say we try to sell it as is in order to reduce that big number of cost side, okay? I know, can I tell about the rejected offer? You have any problem with me?
Which one? Because I've been doing some.
I'm sorry, what?
I've been going back and forth with him, but which, yeah, go ahead.
Okay.
Go ahead. It's transparency.
One of our residents who is a commercial broker and a very respected citizen, in Sandoval, was able to go to the broker that was working for Taylor Morrison to try to sell the property. They had an offer on it for $800,000, which fell through. So he went to this broker and said, hey, were there any offers that they rejected that were below that price? Yes, there was a 620. Okay. Now, who knows if that's right, if that's real? But if it is, or anything well above 500, and we can sell it as is, we can come out of this thing fine. Plus, Kathleen and others are working with Taylor Morrison to delay payments so that we don't have a whole lot of cash flow coming out now.
Morgan and Morgan.
What?
Morgan and Morgan, not Taylor
I'm
and
sorry,
Morrison.
Morgan and Morgan, excuse me. So
Yes.
all those things,
You can piggyback
what we're
on
trying to do is to minimize the impact on us, unless the biggest impact is if you choose to keep it. And if you do, then we need to know what it costs and pay. My own personal opinion is I think we ought to sell as quick as we can.
Marilyn, please. I will. I'll get you. She's been waving her hand over there for a while.
I went to a ribbon cutting for the Cape Coral Caring Center, and the economic development director for the city was there. So I asked her if she would check into, do they have anybody interested in perhaps an office building? Told her where it was. She said she'd check. She called me back today, and she said that she looked at it and she thought that the only problem that she could see just by looking at the map, not the building, was that there was probably a lack of parking, but that could be corrected with the amount of land that's there. And she said she was only working with one client, and she had nothing to offer him, and he happens to be a chiropractor who is leasing a building, and his lease is up this summer, so he has to make a decision soon on whether he's going to build or buy or release, but he really wants to buy a building. So what I did was I told her to get in touch with Kathy, our manager, because she has the keys to the building. So it may be that there are potential buyers out there.
Thank you. Mr. Ponzo, do you have anything? I'll get to you.
I'd say pretty much everything that I do question. When you present, I assume all of the work that you've done is in the form of an Excel spreadsheet with all of its, you change one number and the other numbers change. So is that something that you can put out to the community and protect it in such a way that we can't, we can put different numbers in ourselves, but not compromise your original work?
It's a little difficult to do because the formulas are there.
Yeah.
We can give you a PDF. We can give you basically a PDF, and
PDF
you can kind of manually do it. These are all additions, subtractions. I mean, going from annualized to monthly, you probably aren't interested in the monthly. We just put it in there.
Yeah.
We like to think budgets, okay? So we take big numbers and bring them back to monthly budgets. So that's why we put that in there. But a lot of these numbers are just, if you want to take a number out, you could just take your little calculator and subtract it and do it. It'll involve some pencil things, but we want to post this report, correct?
This particular exercise is actually, you really aren't going to play with those numbers too much. I mean, and one number does not necessarily change another number on there. There's not formulas inserted within that presentation so much. But other than the fact of if we're going to sell it as is, okay, instantly the 362 or drops down to 262 because we
That's pretty simple.
Just erased $100,000 of trying to rehab it. So that I'm talking about your stuff that you created on the next pages.
I did the whole thing.
Oh, okay. Well.
Okay, Ruthie Marzullo. She left. Does somebody have her question? Okay.
I would like to make one comment. I wish you wouldn't send out that thing as is, because to the extent that you identify any bidders on this work, that might be considered confidential.
Well said. Yeah. We'll
Joy Matz or okay. Linda? I'm good, thanks. Okay. Kimberly?
It's me. I'm Kimberly Grove, Burial Court. I feel as if we should have been notified. I don't need a mic. I'll just talk about it.
It's for the people at home.
Okay. I just feel that you're including us in this decision now. It's a money pit. Why weren't we included? And I understand there's provisions with the board because the attorney had mentioned something around that. But this has been going on for quite some time. Why wasn't there something put out for the homeowners to say whether or not it's in our best interest to purchase this and do the deal that they did at the beginning? Now we're stuck with this money pit. Now you're asking all of us, what do you think we should do? So why weren't we included in the beginning with this? I think it's very, very frustrating.
Because it was attorney-client privilege and it was in the hands of the board of directors, and we could not reach out to the community for the opinion. The decision lied with the board of directors, and we could not. I wish we could have.
Our opinion on it?
No, we could not. No, we could not. That's why we are doing it now. We do feel that everybody deserves a right to have a say and to vote. I'm very sorry. I wish it could have been different. Believe me. Marlene? You need your microphone first, Marlene.
My question was probably to the lawyer. He talked about lake erosion, and he's including phase 3. Did anybody ever look at the other phases? In my backyard, I have 2 huge gullies that are from the water up. Now I'm being told those are going to have to be paid for by either the HOA or myself. Well, if it's myself, they're going to stay there, but there's going to be a liability because if somebody walks back there and it's dark.
When did that start?
Approximately 3 years ago, 4 years ago.
Okay, I can't speak for that. No, anybody else?
Catherine
Pardon
has
me?
seen them.
We got this, so it's either her or all of us. So that's going to be somebody has to look at it, determine what it is, and come up with the correct solution.
Catherine has seen it.
Make sure she doesn't have to.
Kathy has seen it? Okay.
Yep, she has seen it.
Okay. Mr. Dunker? Did you signed up to ask, do you have questions, or?
I think most of mine have been answered. I just want to thank, frankly, Todd and David for the tremendous amount of work that they put in developing these calls.
Can I get him? Because he keeps raising his hand, and I just go ahead. That we're finding that out too.
Commercial.
It's zoned commercial, but we're finding more out from what I understand.
Just one quick question.
It's zone Z2, C2.
Thanks. This is due diligence, and it's good due diligence. My question is, was it done before February 28th when you made your decision to take title to this land?
This work was not done.
What was the due diligence before February 28th when you decided to take title?
Their input was considered at that time. But their input was considered.
Correction, I was on the board at that time, and I had a fiduciary responsibility to go with what I saw, and that's why I voted no.
Anybody else? Hey, ma'am? Lady in pink or peach.
The talk and I wasn't on the board.
The talk about rehabbing and the cost of that is almost a moot question, isn't it? Because we already know that it doesn't have a certificate of occupancy. So as far as considering a chiropractor there or a professional office, it's a moot question. No certificate of occupancy.
But just let's allow people to have their input in on it and let them see the numbers, have a hands-on workshop one day, and they can come to that. But I don't think we can just knock it off the board. I think it has to go to vote for them. When they see the numbers, I'm sure that...
But it's not the numbers I'm talking about. It's the certificate of occupancy that will not be allowed for that triple mobile. It's illegal, isn't it? Since now Taylor Morrison has moved out of that building, there is no certificate of occupancy.
I don't know that, but I will look into that and
Thank
ask.
you.
Okay. Behind you.
Just real quickly, Scott DeFilippis again, and I thank the two gentlemen up there for the work they've done. The numbers are fantastic, but and this is just my opinion. I've been here for 10 years. We moved in on Stony Hill as a new house, and I just want the residents to know, I know that carrot dangling in front of our face of money is really, really tempting. But what I would caution you as, and again, it's going to be a difference of opinions, but we went through this 2 years ago when the property to the north of us was going to be apartment complexes, and we were have that shoved down our throat because our city has this infinity for granting variances. And I've been in real estate long enough to know when I hear best and highest use, it's not good for the surrounding community. And we're going to be back here again when we find out that place that they're going to put right at our gates that we're going to see 365 days a year, 24 hours a day, is what we didn't want, and we could have had an option. And I'm just going to put it out there that, in again, my humble opinion as a resident and a realtor, the highest and best use is with these great numbers here. We demo the building, we turned it into green space, and we never have to look at something that we regret. We take the carrying costs and we go back to $200 a quarter to maintain it, and we're done with it. So with that being said...
Is that a question? I'm just joking.
Would anybody agree to that comment?
That's that number, 254.
Jerry?
This is really not a question. I just want to know, I love this presentation. Thank you so much. It gives us a great idea. I understand this gentleman's hesitation about the bid, the source, the bid. Could this be made available to the residents? I know it's being televised, taped, but many people don't look at it. Can this be sent to the residents before the May?
The issue I would have, and we can talk about it, the board will talk about it. The issue I have is, do we want all these numbers out there if we're trying to find a very good buyer, if that's where we go?
I understand that, but...
Sellers already know the numbers, so we have to disclose them anyway. So any potential buyer is going to, it's might as well let the rest of the...
And I think that to just have this not available until, we'll say, the May meeting, I would like to look at these so that I could kind of really think about these. And I think many residents would like to just say, I mean, if I come back and say, yeah, well, 361,000, and then if we do a lease, there's another 40,000, and it could be be a $254 assessment per home, per household. I think this really is great. And there are guesstimates. They're not written in stone that these are all the right figures, but I think it gives you a great idea, and I just think that this is transparency, showing something like this, and I think the residents would appreciate getting this, even though you're taking the chance that maybe there's a buyer out there that will see that and won't like it, and they'll use it as a negotiation tool.
I don't know. How does the board want to move? I need your opinion. I can't make that decision, so.
What was the question?
The question is, can we put this information out on paper to the residents or on email, I assume?
I wouldn't. We don't have any reason. In commercial real estate, we don't have to disclose any of these numbers. I don't see any reason that we should have to disclose this. I think that if residents would like a copy of this, that it would be up.
That's what she's asking.
That it would be something you could probably go and pick up at the office. But yeah, I think that you probably can, but that would be I think that I would defer that question to our general manager because as a board, we're finding it difficult to keep privileged information from being discussed outside the board meetings. So if we were to release something like this, this document, absolutely, it would go all over the place. So I don't feel like not giving it out is going to solve anything, but I can't make the decision that it's okay to give it to everyone.
Marilyn's opinion?
I think the $155,000 that we have to pay should never have been added into the building cost.
Agreed.
I think if you subtract it from 361, it changes all the numbers, particularly your rental numbers on the last page. And some of those numbers, I believe, are inflated. Okay. And so consequently, I find it very difficult to believe what has been present.
These do appear to be worst case scenario numbers.
Okay, so go ahead. Sorry.
If you're going to present options to the residents, demolish it, lease it, find a buyer, you're going to have to give them numbers like this anyway as to the cost of each item. Well, so you're eventually going to have to get this out, whether it has to be in this form or whether it will be modified a bit. You can't ask these people to make a decision between options without telling them the cost of each option.
Correct. Yeah, you are correct. You are correct. That's the purpose of the workshop, too. To wait till May? Okay, we have to talk about it a little further, and then give a good answer. Because there are some concerns with the seven of us, and I don't think we're in total agreement. Do we want to take a vote on it for tonight and then move it? No. Okay, so no. We will get back.
The 155 is appropriate to put in there because, in fact, that is the acquisition cost. Don't think of it as to Morgan. That's what our cost is to acquire that. So why wouldn't it be, if this was a normal analysis of a property that we spent money for and needed to then put it on the market to determine how much we're involved in it, that needs to be there.
Well, I think it inflates the numbers to make it unrealistic when you look at the total of leasing it, where they were putting, you have to lease it for $7,000 a month because you're amortizing that $155,000. But Morgan and Morgan wants their money now. That's not part of the 150.
If you're leasing it, in order to be able to receive any monies from a lease, you have to own the piece of property that you're leasing. And the 155 is our cost. So it's not an inflated figure. It's in fact our acquisition fee for the piece of property.
The 155 does not go away, regardless how you look at it. We're responsible to pay that. But if you look at the 361 and you take the 100 out, that's 261. That would cost us $20 a month in our dues. And then when you look at the next page, if we wanted to keep this property, you go to the next page when it's $3,700, $3 a month on an ongoing basis. So it's an initial purchase of $20 a month for a year, and then an ongoing $3 a month to keep it if you want to keep it, as Scott is saying, green. So it's a good suggestion that Scott made. We just have to make sure we understand which way we're going. Now, my opinion is I don't want to be a landlord. I don't want to lease it. I think that's the one item that I would hope that we would drop first, and then it's a matter of sell or keep the property. That's the way I would personally look at it. Next person.
Are we good with questions tonight, or because it's
I have two quick questions.
Okay.
I got two
Todd?
quick things.
Sure.
You know, first of all, cost or cost. Cost or cost. This is a pro forma. This is to give an idea. Is it 100% accurate? No. But I would challenge anybody to put that to the test. And at the end of the day, once everything goes through the net, I guarantee you we'll be close to that. Okay? My other quick comment, as we wrapped it up, there was an accusation made that Mr. Ciganek arbitrarily moved $1.1 million from the reserve, from operating to reserve.
Not arbitrarily.
That was absolutely incorrect. There is a due from and a due to on the balance sheet that needed to be cleared, and those represented designated reserve funds that needed to be moved into the reserve account. That was an internal transaction. There was nothing related to arbitrarily or whatever moving money. It was to clear an accounting entry, and from my understanding, that still has not been done.
So what you're saying is...
On my report, we're going to address those issues with this new finance committee. We're going to get that clearer.
It was, the word arbitrary was not used. The statement that I made was factual, that we transferred funds from the operating account to the reserve account. It was owed to, and it was a loan that we took from ourselves. Did that not happen?
Do we need further discussion on it? Okay, a motion to end the meeting, and we will get back to that question.
A motion to end the meeting.
Second, all in favor?
Aye.
Dave, Todd. Thank you, everybody.